So we'll start with the fundamental rights. The fundamental rights, the Mandakhiva, it is under part 3, articles 12 to 35. These are about fundamental rights. Their purpose is for the material, intellectual, moral and spiritual development of the individuals. Material development, intellectual development, moral development and spiritual development. So it has been borrowed from the US era Bill of Rights, and it is unique because it is more elaborate than in any other country. So note this, it is described as the Magna Carta of India. Magna Carta, it out a document signed in 1215 between the king of Britain and the parliamentarians, where there was transfer of rights from the king to the individuals. Okay, thus the challenge was done to the divine rights of king theory, and power are transferred from the king to the individuals. And features of fundamental rights, it is amendable by parliament by a constitutional amendment, but the amendments cannot alter the basic structure of the constitution. They are qualified rights, they are not absolute, and they are subject to reasonable restrictions under article 19. Protection against state and individual, they mostly shield from state action, but there are some fundamental rights that also shield the individual from private action also. They are both positive and negative in nature. Negative और positive माने कौन, गोटे नेगेटिव माने दे लिमिट स्टेट अथॉरिटी, तो स्टेट कौन कौन करि पारिबनी, स्टेट ऊपर प्रोहिबिशन कौन सब अच्छी, आ पॉजिटिव माने स्टेट कौन करवा दरकार, ओके, टुवर्ड्स दी वेलफेयर ऑफ इंडिविजुअल. तो confer privileges on individual, some rights, and some rights they say that state should not do this thing. So accordingly they are called negative rights and positive rights. We'll see about them. Democratic in nature, they are a check on the executive and legislative tyranny. Okay, so they, because they limit the action of the state, they are a check on the arbitrary decision making of both executive and the legislative. They are justiciable, they are enforceable through courts, they are claims against the state. Okay, fundamental rights are citizens claim against the state and not vice versa. The state, not the claim of state on the citizens. Okay, they are citizen claim against the state. Okay, so there are some rights are given to the citizens, and the state cannot violate those rights. Okay, so that is the idea of fundamental rights. Suspension, during national emergency they can be suspended except the articles 20 and 21. Article 20 is protection with respect to conviction against certain offences. Article 21 is about right to life and liberty. Okay, now suspension of article 19 rights, they are suspended. Okay, article 19 तमर जो freedom दिया है जी, सब 6टा freedom दिया है जी, they are suspended during external emergency. Okay, they are not suspended during internal emergency or armed rebellion. Okay, केवल external emergency during times of external aggression or war, only then article 19 of freedom they can be suspended, and not during internal emergency. So this is a fact, please note. Now constitutional provisions, एटा मैं already कही तमरा 5424221. Okay, 5424221, 54241. Okay, फास्ट होची राइट टू इक्वालिटी, तुम 5टा राइट अच्छी 14, 15, 16, 17, 18, 5टा राइट. देन राइट टू फ्रीडम, तुम 4टा राइट टू फ्रीडम रे तुम 4टा आर्टिकल अच्छी 19, 20, 21, 22. राइट अगेंस्ट एक्सप्लोटेशन 2टा राइट 23 एंड 24. राइट टू फ्रीडम ऑफ रिलीजियन 4टा राइट 25, 26, 27, 28. कल्चरल एंड एजुकेशन राइट्स 29 एंड 30 2टा आर्टिकल. एंड द राइट टू कॉन्स्टिट्यूशनल रेमेडी आर्टिकल 32. ओके, सो एटा मन रखिद तुम 54241. ओके, कॉन्स्टिट्यूशनल प्रोविजन टू गारंटी द फंडामेंटल राइट्स. राइट टू प्रॉपर्टी, एटा आगु आर्टिकल 31 थिला, बट इट वाज डिलीटेड विथ द 44th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट 1978. ओके, नाउ राइट टू कॉन्स्टिट्यूशनल रेमेडीज तुम आर्टिकल 32 रे अछि. 44th अमेंडमेंट एक्ट 1978 रे इट रिमूव द राइट टू प्रॉपर्टी article 31 from the fundamental rights. It was right to property was reclassified as a legal right. It was a legal right or constitutional right, and it was no longer a fundamental right. Now it article 300A re achi, the state cannot remove the property of anyone except the authority of law. Okay, तुम एटा part 12 रे article 300A ए दिन छटा मन रखिबो, part 12 300A रे right to property is a legal right or constitutional right, but no longer a fundamental right. Now availability of fundamental rights only to citizens, तुम article 15, 16, 19, 29 and 30. Okay, पांचटा आर्टिकल तुम अवेलेबल ओनली टू सिटीजन्स. Okay. Article 15 prohibition of discrimination based on religion, race, caste, sex, place of birth. Article 16 ensures equal opportunities in public employment. Article 19 freedoms. Okay, what are the freedoms we will see. Article 29 it is the protects the cultural and educational interests of minority groups. Article 30 again grants the minorities right to establish and manage education institutions. Article 21A right to education. Okay. This much were available. These fundamental rights are available only to citizens. Now the fundamental rights to citizen plus foreigners. Foreigners will exclude enemy aliens. Please note this, they will exclude enemy aliens. Article 14 right to equality and 20 to 28. Okay, 20 to 28 तमें जान 20 is protection with respect to conviction against certain offences. 21 is right to life and liberty. 22 is protection against arrest and detention. 23 is prohibition of traffic in human beings and forced labour. Article 24 prohibition of employment of children in factories. 25 is the practice, propagation and profession of religion according to conscience. Article 26 is freedom to manage religious affairs. 27 is no taxes to promote any religion. 28 is freedom to attend religious instruction or worship in education institutions. Okay, so this much तुम एटा 14 आ 20 ରୁ 28 these are available to all citizens plus foreigners except enemy aliens. आउ तुमर पांचटा रहिला these are available only to citizens, that is 15, 16 article freedoms. These freedoms are number article 19, then 29 and 30. Okay. So now definition of state and laws inconsistent with fundamental rights. So definition of state is given under article 12. So it includes the government and parliament of India, government and legislature of states, all local authorities like municipalities, panchayat, district boards, improvement trusts, etc. and other authorities like the statutory and non-statutory bodies like जोटा कि PSU जमती तमरो ONGC, LIC ये सब, that these PSUs they take funding, they are from the state, they are run by the state, that's why they are authorities under state. Okay, तो गोटे जिनस टेक्निकल जिनस मन रखिबो आर्टिकल 12 रे judiciary is not considered as a state under article 12. Okay, please note this point, judiciary is not considered under state within the definition given by article 12. Okay, so बाकी रहा तुम गवर्नमेंट एंड पार्लियामेंट ऑफ इंडिया, गवर्नमेंट एंड लेजिस्लेचर ऑफ स्टेट्स, सब जाक लोकल अथॉरिटी लाइक म्युनिसिपालिटी, पंचायत, डिस्ट्रिक्ट बोर्ड्स. ओके, सो ये सब जाक स्टेट डेफिनेशन आसवे. सुप्रीम कोर्ट अकॉर्डिंग टू सुप्रीम कोर्ट इवन प्राइवेट बॉडीज और एजेंसीज दैट आर वर्किंग एज इंस्ट्रूमेंट ऑफ द स्टेट ऑल्सो फॉल अंडर आर्टिकल 12. ओके, जदि प्राइवेट बॉडी अच्छी, जदि से स्टेट सागर मिसे किसी काम करुँच कि स्टेट रू सिग्निफिकेंट फंडिंग नौकरी से भी स्टेट डेफिनेशन रे आसवे. ओके, now laws inconsistent with fundamental rights article 13. okay, article 13 रे तमरो laws को define कराई छी और judicial review रो philosophy दिया छी article 13 रे. okay, so the principle is any law that is inconsistent or derogating the fundamental rights will stand null and void. okay, and article 13 explicitly provides for the doctrine of judicial review. जहाँ भी law आसीबा that is subject to judicial review. If they are inconsistent with fundamental rights, then they will be nullified. Okay, meaning of law under article 13. article 13 clause 3 रे तमरो law रो meaning दिया है. What are laws? Laws by the permanent laws by center and states, temporary ordinances by the president or the governor, delegated legislation. okay, the rules, orders, bylaws and notification, delegated legislation from the legislature to the executive, or the custom or uses having the force of law. okay, okay, when customs can also have the meaning of law under article 13 clause 3, and if they violate fundamental rights they will be nullified. okay, custom or uses जेमती तुम religious custom कि social custom ए सब इवेन तो आम constitution ये imply करुच्ची that constitutional morality will always be superior to religious or local laws. okay, local morality ये जिनसटा तुम कहीपर. okay, constitutional morality will always be superior to the customary morality or the religious morality that can be derived from article 13 clause 3. now Article 13 clause 4 and constitutional amendment. Okay, 24th constitutional amendment re 1971 re it was declared that article 13 does not apply to constitutional amendment under article 368. Okay, article 368 under part 20 जहाँ भी constitutional amendment तैयारी कर जीवो it will not be counted as a law under article 13. Okay, से जिनसटा 24th amendment रे article 13 clause 4 गोटे insert करागला. Okay, but in the Kesavananda Bharati case in 1973 Supreme Court ruled that a constitutional amendment can still be challenged if it violates the fundamental rights forming part of basic structure. Okay, तो fundamental rights को change करी हबो ठीक, but basic structure को violate कर परिबोनी. Okay, जहाँ भी constitutional amendment parliament करूची. Hence such an amendment can be declared void if it violates the basic structure. All right, now comes right to equality. So article 14 it states that the state shall not deny to any person equality before law or equal protection of law within territory of India. It applies to every person, all person. Okay, citizen plus foreigners, it applies to everyone. So देखो एटा गोटे नेगेटिव कमांडमेंट, स्टेट शैल नॉट डिनाय. ओके, सो दिस इज ए नेगेटिव डिक्टम. आम जमी देखिले डिक्टम कैन बी ये जो जिन देखिले राइट्स कैन बी बोथ पॉजिटिव एंड नेगेटिव. ओके, आर्टिकल 14 रे स्टेट शैल नॉट डिनाय, स्टेट कोटा करि पारिबोनी बिकॉज जोटा करि पारिबोनी सेटा को नेगेटिव कह जाउछि. ओके, जोटा करि पारिबो सेटा पॉजिटिव आम देखिया पारे. So article 14, the state shall not deny to any person equality before law and equal protection of law within territory of India. Okay, it applies to all persons. तो दुईटा प्रिंसिपल अच्छे आर्टिकल 14 रे, इक्वालिटी बिफोर लॉ एंड इक्वल प्रोटेक्शन ऑफ लॉ. ओके, इक्वालिटी बिफोर लॉ को तुम EBL कहि परिबो. एटा B फॉर ब्रिटेन. ओके, B फॉर ब्रिटेन, तो EBL बिफोर ब्रिटेन. सो इट इज ए नेगेटिव कॉन्सेप्ट, मीन्स एब्सेंस ऑफ प्रिविलेज, कहा को स्पेशल प्रिविलेज दिया हबनी. ओके, दैट्स वाई एटा हम जमी कहले नेगेटिव डिक्टम, सेमती EBL इज ए नेगेटिव कॉन्सेप्ट, कहा को स्पेशल प्रिविलेज दिया हबनी. सेमती इक्वल प्रोटेक्शन ऑफ लॉ रे इट इज ए पॉजिटिव कॉन्सेप्ट, इम्प्लाइज इक्वल ट्रीटमेंट, समस्त के इक्वाली ट्रीटमेंट करा हबो. ओके, जो जिनसटा करा हबो सेटा पॉजिटिव कॉन्सेप्ट, जो जिनसटा करा हबनी सेटा नेगेटिव कॉन्सेप्ट. ओके, ए जिनसटा आई थिंक यू हैव अंडरस्टूड इट. इक्वालिटी बिफोर लॉ इट इज ए नेगेटिव कॉन्सेप्ट बिकॉज इट एम्प्लाइज कहा को स्पेशल प्रिविलेज मिलिबो नाही. Okay, so feature no special privilege for any person, equal subjection of all persons to the ordinary law of land. Okay, ordinary law under रे समस्ते try करा है. Okay, in special in ordinary courts in the land. Okay, no one is above the law, that is the rule of law principle. Okay, केवल law रो ही rule चलिबो, आउ कहार rule चलिबोनी. That is the concept of equality before law, EBL Britain runaich. Now equal protection of law, it is an American concept. It says that equal treatment माने equality of treatment under similar circumstances. Okay, so equal should be treated equally, unequal should be treated unequally. Okay, जो माने सेम अछंती तांको सेम ट्रीटमेंट दिया जाऊ, जो माने सेम नहांती तांको सेम ट्रीटमेंट न दिया जाऊ. Okay, that is the idea. Features equal treatment under similar circumstances, same laws apply equally to all persons who are similarly suited. Okay, like should be treated alike. Okay, no arbitrary discrimination and unequal should be treated unequally. Okay, for example से जो आमर रिजर्वेशन जमती अच्छी तुमर जनरल पिला सांगे तुमर रिजर्व कैटेगरी तांकर मार्क को इक्वल करा हबनी बिकॉज दैट इज इक्वल प्रोटेक्शन ऑफ लॉ. Okay, because that is an attempt to bring both the sections under the equal pedestal so that equal opportunity is ensured. Okay, so I think that is the idea. I think you are clear about this. Equal protection of law is about justice. Equality before law, it is about equality. Okay, so equal EBL and EPL এটা তুমি দেখিলো. Now judicial interpretation, देखो equal and unequal should be treated differently. Article 14 is not violated. Okay, यदि equal को equally treat करो और unequal मान को unequal, okay sorry, यदि equal और unequal, okay, यदि तुम equal और unequal को अलग अलग treat करो, then Article 14 is not violated. Okay, right to equality violate हबनी. So it forbids class legislation, means laws must not discriminate between classes. Okay, so it should try to give everyone equal opportunity. Now it permits reasonable classification. Okay, reasonable classification means it the discrimination means the criteria जो criteria रे तमें decide करछो जे ए माने equal और ए माने unequal that criteria should be based on intelligible differencia okay तो तुम डाटा फाटा नहीं डाटा फैक्ट नहीं कि तुम ये क्राइटेरिया को डिटरमाइन करो क्या को इक्वालिटी ट्रीट करिवो क्या को अनइक्वालिटी ट्रीट करिवो एंड this classification should have a rational nexus with the objective being sought because our objective is to bring everyone social justice तो social justice करिया को हेले तुमको ये जो इक्वल अपॉर्चुनिटी देवा को पड़िवो इक्वल अपॉर्चुनिटी देवा को हेले तुमको क्लासिफिकेशन करिया को पड़िवो ओके सो that has a nexus connection with the our objective of social justice okay so reasonable and this classification should not be arbitrary artificial or evasive okay so एमती तुम मन इच्छा क्लासिफिकेशन कर परिबनी जहाँ भी क्लासिफिकेशन करिवो ता पई गोटे इंटेलिजिबल डिफरेंशिएशन क्राइटेरिया रहिबो इट शुड हैव ए रैशनल नेक्सस विथ द ऑब्जेक्टिव दैट इज बीइंग sought to be achieved by the state government and it should not be arbitrary artificial and evasive okay now the laws the unguided and uncontrolled discretionary powers conferred on authorities also violates article 14 okay तो authority माने जहाँ भी law करिवे they cannot be arbitrary they should follow this equality before law and equal protection before law okay so this article controls the unguided uncontrolled arbitrary and discretionary power of the authorities okay now the concept of rule of law ए जिनसटा A.V. Dicey देले he is a British political scientist so rule of law is a basic feature of constitution that is declared by Supreme Court equality before law EBL is a key component of okay rule of law रा तमरा तीनटा component अछि तीनटा principle अछि rule of law रा first principle is there should be absence of arbitrary power okay applicable in India तो arbitrarily कहीं power exercise करि परिबेनी there is checks and balances and the constitution will limit the arbitrary power making of the legislature and equality before law एटा में देखिले applicable in India तो law before law everyone is equal primacy of individual rights as defined and enforced by courts and not constitution okay तो ए जिनसटा तम ब्रिटेन रे अछि it is not applicable in India okay constitution is the source of rights ये कौन कहते जे primacy to individual rights as defined and enforced by courts okay कोर्ट जहाँ डिसाइड करेंगे अकॉर्डिंगली इंडिविजुअल राइट्स आसो बट इंडिया रे कॉन्स्टिट्यूशन ही इंडिविजुअल मानू राइट्स देछि ओके नाउ एक्सेप्शन टू इक्वालिटी आर्टिकल 361 प्रेसिडेंट एंड गवर्नर दे एंजॉय ओके दे एंजॉय लिमिटेड इम्यूनिटी ओके बिकॉज तांकर सिविल और क्रिमिनल केस रे ओके जदि तांकर सिविल केस रे जदि तांकर किछि तांकर भीतर किछि केस चलला देन ओनली दे कैन बी कॉल्ड क्रिमिनल केस रे समान दे एंजॉय इम्यूनिटी ओके आर्टिकल 361A ओके प्रोटेक्शन फॉर पब्लिकेशन ऑफ सब्सटेंशियली ट्रू रिपोर्ट ऑफ पार्लियामेंट और स्टेट लेजिस्लेचर प्रोसीडिंग न्यूज़पेपर रेडियो एंड टीवी ओके तो 361 रे इट इज प्रोटेक्शन टू बोथ legislator and publisher okay protection for both legislator and publisher unless the publication is made with some malified intent okay 361A so publication of substantially true reports this protection is valid for both the legislator as well as publisher so एथरे तुमर इक्वालिटी अप्लाई हेनी फॉर लेजिस्लेटर्स एंड पब्लिशर्स आर्टिकल 105 पार्लियामेंटरी प्रिविलेजेस ऑफ एमपी से जदि एमपी मैंने किसी भी जहाँ भी ऑफिशियल कैपेसिटी जहाँ भी कहते कि एक्शन कर सो दे आर इम्यून टू दैट एक्शन सो से जिनसटा कॉमन सिटीजन को मे भी मिल न थाई पारे सिमिलरली आर्टिकल 194 105 रे तुम 89 ऐड कर दियो प्लस 89 आर्टिकल 194 प्रिविलेज टू स्टेट लेजिस्लेचर मेंबर्स आर्टिकल 31C if law enacted to implement DPSP under article 39B and C okay any law that is enacted to implement DPSP under article 39B and C it cannot be challenged under article 14 okay when 31C comes in article 14 goes out okay जदि 31C रे जदि कौन से DPSP एनाक्ट करिया पे किसी लॉ आसिला ताहले तमे आमे आर्टिकल 14 कहि कि ताकू चैलेंज कर परिबानी नेक्स्ट foreign sovereigns and diplomats immunity from criminal and civil proceedings to foreign sovereigns and diplomats UN and its agencies they also enjoy diplomatic immunity okay so these are the exceptions towards article 14 that is equality that is principle of equality before law and equal protection of law. Okay. Now Article 15, prohibition of discrimination. Okay. Article 15, prohibition of discrimination. Article 15(1) states shall not discriminate against any citizen on the grounds only of religion, race, caste, sex, place of birth. Okay. Is only taku dekhibo, only on the grounds only of, okay, religion, race, caste, sex, place of birth. Jodi suppose place of birth गोटे क्राइटेरिया संगे सपोज जदि गोटे फाइनेंशियल फ्रॉड एसोसिएट होइछि, ओके, ताहले प्लेस ऑफ बर्थ और फाइनेंशियल फ्रॉड ए दुईटा क्राइटेरिया मिसिकी ताकू डिस्क्रिमिनेशन एवं करी हबो, ओके, तापर इंडिविजुअल ऊपर एक्शन नहीं हबो, बट ओनली ऑन द बेसिस ऑफ प्लेस ऑफ बर्थ तापर किछि एक्शन नहीं हबोनी, ओके। जदि प्लेस ऑफ बर्थ सहित आउ किछि जदि क्राइम एसोसिएट होइछि देन द कैन बी डिस्क्रिमिनेटेड अगेंस्ट बाय द स्टेट, okay. Only means other grounds are not covered here, are outside provision, okay. जदि extra किछि provision add hala then they can be discriminated. Now Article 15 clause 2, no citizen shall face restriction on the above grounds in access to shop, restaurant, hotels and entertainment places, use of well, tank, bathing ghat, roads, public resorts funded by the state or open to public. It covers both state and private individuals, okay. Both state and private individuals cannot restrict the access of anyone to the use of wells, tanks, bathing ghats, roads and public resorts maintained by the state or open to public, okay. Similarly, state and private individuals, they cannot restrict the access of any individual to any shop, restaurant, hotel and places of entertainment, okay. So while Article 15 clause 1 covers only the state, okay. तो यही जिनसटा Article 15 clause 1 एतरे खाली this is a directive towards the state only. Article 15(2) it is a directive towards both citizen as well as private individuals also, okay. तमे ये जो एंटरटेनमेंट शॉप्स रेस्टोरेंट्स तमे प्राइस टैग लेकर रखी पारिबो, ओके। प्राइस टैग देखिकी लोक डिसाइड करेंगे से जीवे कि न जीवे, बट तमे सेमती क्या फोर्सफुली रेस्ट्रिक्ट करि पारिबो नाही, ओके। सो foundation of reservation, okay. Article 15(3) and Article 15(4). Article 15(3) it is about special provision for women and children. Article 15(4) about the reservation towards SCBC, SC and ST, so exception to the rule of non-discrimination, okay. को जगह रे unequals should be treated unequally. इथरे अच्छी तुम को जगह unequal should be treated unequally because special provision for women and children under Article 15 clause 3 because they are vulnerable sections of society, तो ताका पे special provision करी पारिबो state. For socially and educationally backward class and SC and ST under Article 15 clause 4 because they are unequals, they can have special incentive. For SCBC, SC and ST in education institutions, private or aided or unaided, except the minority institution, Article 15 clause 5 re, okay. And EWS section 103rd Constitutional Amendment Act under Article 15 clause 6 एई सेक्शन मानकरे तमरा state can grant exception to the general rule of non-discrimination, okay. Now reservation in education for OBC under Article 15 clause 5, as I have said, in education this reservation in education institution was made by 93rd Constitutional Amendment Act of 2005. Please note my Constitutional Amendment Act पचार दिए statement हिसाब रे, तो 93rd Constitutional Amendment Act रे 15 clause 5 add करा हितला, okay. It enabled 27% reservation in central higher education institution like IITs and IIMs. Supreme Court upheld the validity of this amendment but applied criminal exclusion, okay. And EWS Article 15 clause 6 added by the 103rd Constitutional Amendment Act of 2019, okay. It provides 10% reservation for EWS in education institutions for the general category students who have not availed any other reservation, okay. Now creamy layer and subclassification of in SC and ST reservation. The earlier position thila in EB Chinaya versus State of Andhra Pradesh 2004 case re Supreme Court held that the subclassification of SC and ST is impermissible as the SC and ST they are a homogeneous group, okay. But recently Supreme Court has overturned this EB Chinaya judgment and said that states can subclassify SC and ST within the quota for targeted benefits, okay. So Supreme Court has said that creamy layer principle should be extended to advanced groups and privileged groups within SC and ST, and sub-classification must be empirically backed. 100% reservation for any subclass is not allowed, that is true, and reservation is limited only to the first generation beneficiaries. Okay, so this is the Supreme Court observation in the EB by overturning the EB Chinaya case. Okay, Supreme Court has said that SC and ST are no longer a homogeneous category, and the criminal principle that is applied to OBC section should also be applied to SC and ST category. Now comes the Article 16, equality of opportunity in public employment. So the principle is the aims to provide equality of opportunity to all citizens in matter of public employment or office under the state. No citizen can be discriminated against on the grounds only of religion, race, caste, sex, descent, place of birth or residence. Okay, residence condition re tamar gote exception achi. Residence condition, Parliament may prescribe residence as a condition for jobs in a state, UT or local authority. Okay, Parliament may prescribe this condition. So this condition is currently applicable only in Andhra Pradesh and Telangana. Okay, so this is under Article 16 clause 3. Article 16 clause 3 lekchi residence as a condition for employment. For that law, Parliament has only the authority to make such law to enable residence as a condition for employment in a state, UT or local authority. Okay, now reservation for backward classes. State may reserve post for social and educational backward classes who are not adequately represented in government employment under Article 16 clause 4. So Article 15 ta tamara thila prohibition of discrimination. Article 16 ta thila tamara equality of opportunity in public employment. Okay, ता भितर सब एवढा अच्छी 16 clause 4 रे reservation to backward classes. In religious and denominational institutions, laws may require the incumbent of the office to belong to a certain religious denomination. This is under Article 16 clause 5. Reservation for EWS, state may provide up to 10% reservation for the EWS section under Article 16 clause 6. Now the Indra Sahani judgment 1992, it is a landmark on Article 16 clause 4, that is the reservation for backward classes. So this judgment upheld the 27% OBC reservation with conditions that the creamy layer or advanced section should be excluded, okay, from the OBC reservation, and it rejected the additional 10% reservation for poorer sections. Okay, so ei dinsota additional 10% reservation eita ebe EWS reservation re aschi, eta already tomara इंदिरा साहनी जजमेंट रे एटा को तमरो फास्ट ए दिनसटा को तमरो नलिफाई कर दिया हितला, बट एबे ईडब्ल्यूएस रे दिनसटा एक्सेप्ट करा हिच. सो इन दिस जजमेंट द 50% cap on total reservation except in extraordinary situation. Okay, no reservation in promotion, that is, and the reservation is limited only to the initial appointments. Carry forward rule is valid but cannot breach 50% ceiling. So carry forward rule is the unfilled backlog vacancies can be carried forward to the next year vacancies also without breaching the 50% ceiling. Okay, recommended permanent statutory body to examine inclusion or exclusion of backward classes. This led to the formation of NCBC. Okay, NCBC, it was established by an act of parliament in 1993. It was a statutory body, but it was given constitutional status by the 102nd CAA in 2018. The article 338B deals with the NCBC, National Commission for Backward Classes. Okay, एटा सब थला इंदिरा साहनी जजमेंट रो. अब बैकवर्ड क्लासेस कमिशन एंड रिजर्वेशन पॉलिसीज ऊपर टी देख दबा. फर्स्ट बैकवर्ड क्लास कमिशन अंडर आर्टिकल in 1953. So this was under article 350. Chairman was Kaka Kalelkar. It was tasked with identifying and suggesting measures for improvement of SCBC. Okay, a second backward class committee under 1979. Chairman under BP Mandal under article 340. Okay, article 340 ସେଥିରେ ଲେଖା ହେଇଛି that the president should appoint a commission to investigate the condition of backward classes. So accordingly 1953 ରେ କାକା କଲେଲକର କମିଶନ ଆସିଥିଲା, 1979 ରେ ତମର BP ମଣ୍ଡଲ କମିଶନ ଆସିଥିଲା, ତ ଦେନ୍ 2017 ରେ ତମର ଜଷ୍ଟିସ୍ ରୋହିଣୀ କମିଶନ ଆସିଛି, ସେଟା 2017 ରେ ତମର ଅଣ୍ଡର ଆର୍ଟିକଲ 340. ଓକେ, ସୋ टिके देखिदवा बीपी मंडल. सो तांकर फाइंडिंग कौन था, 52% ऑफ इंडियन पॉपुलेशन इज एससीबीसी एक्सक्लूडिंग द एससी एसटी. ओके, एससी एसटी को छाड़ी एससीबीसी 52% ऑफ इंडियन पॉपुलेशन. इट रिकमेंडेड 27% रिजर्वेशन इन गवर्नमेंट जॉब्स फॉर द ओबीसी. सो इट एंश्योर्ड टोटल रिजर्वेशन वाज कैप्ड एट 50%. ओके, सो दिस वाज द बीपी मंडल्स रिकमेंडेशन. implementation तो 1979 रे हेतला ओके 1979 रे हेतला एटा बट इम्प्लीमेंट कराला 1990 रे VP सिंह गवर्नमेंट ही दैट गवर्नमेंट डिक्लेयर्ड दैट 27% OBC reservation in government jobs again in 1991 under the Narsim Rao government dita major change karagala preference within OBC quota to poorer sections that is the economic criteria ei through tomara creamy layer okay this was the creamy layer condition okay to poorer sections economic criteria ଏଇଥିରେ ତୁମର creamy layer condition ଆସିଲା additional 10% reservation in jobs for poorer section of higher caste ଏଇ ଜିନିଷଟା ତୁମର ଇନ୍ଦିରା ସାହାନୀ ଜଜମେଣ୍ଟରେ ସୁପ୍ରିମ କୋର୍ଟ ନଲିଫାଏ କରିଦେଇଥିଲା ଯେ the reservation is not a step towards economic upliftment of the people but towards social justice for the historic discrimination okay नरसिंह राव गवर्नमेंट ଏଇଟା ଗଲା ତୁମର creamy layer ଗଲା ତୁମର गोटे जिनस यहाँ देखिए बीपी मंडल कमिशन एटा सेकेंड बैकवर्ड क्लासेस कमिशन एटा 1979 रे एटा मोरारजी देसाई गवर्नमेंट रे आस्थला मोरारजी देसाई गवर्नमेंट रे 1979 रे बीपी मंडल कमिशन हेइतला तांकर इम्प्लीमेंटेशन बेलू 1990 हे गला अंडर बीपी सिंह गवर्नमेंट देन दी नरसिंह राव गवर्नमेंट इन 1991 ओके नाउ जस्टिस रोहिणी कमिशन Justice Rohini Commission, it was constituted under Article 340 like the other previous commission. So, its objective was to address the unequal distribution of reservation benefits among OBC. Key mandate, develop a scientific approach for OBC subcategorization. OBC subcategorization, it is the main goal. Identify and classify the caste in central list and review the list for errors, repetitions and inconsistencies. Okay, 2020 रे mandate expand कराला to correct the ambiguities and transcription errors. Transcription errors means जोटा कि भूल entry हो जाएगी कि exit हो जाएगी, those are transcription errors. And Justice Rohini Commission का report, this is not 100% public yet. Okay, it is not yet 100% public. So this much about the Article 15 and 16. Now comes Article 17, abolition of untouchability. It abolishes untouchability and forbids its practice in any form. Okay. Now Untouchability Offences Act 1955 amended in 1976. Okay, and renamed as Protection of Civil Rights Act. Okay, POCRA. POCRA 1995. It is about the to prevent untouchability. So untouchability is not defined in the constitution. Mysore High Court said that Article 17 covers not the literal meaning but the historic practice of untouchability in India. Okay, it does not cover the social boycott of individuals or exclusion from religious services. Okay, the religion religious institution रिलीजन रो ही ग्रुप रिलीजन रो ही बिलोंग करिया कथा सेमिति किछि कहले that is not the meaning of untouchability. Okay, just untouchability refers to the historical practice of untouchability that was practiced in India, not the literal meaning. Okay, तमरो COVID-19 रे social distancing रो जो रूल्स गुड़ा थिला तो that does not mean कि untouchability एथरे प्रमोट करछि गवर्नमेंट. Okay, People's Union for Democratic Rights case 1982, rights under Article 17 applies against private individuals. State has the constitutional obligation to prevent violation against untouchability under this article. Now Article 18, abolition of titles. So there are four provisions prohibit state from conferring any title except military or academic on anyone means citizen or foreigner. Prohibits Indian citizen from accepting any title from foreign state. Okay, then foreigners holding office of profit or trust under the state cannot accept title from foreign states without the presidential consent. Okay, तो जो फॉरेनर माने भी जदि ऑफिस का प्रॉफिट के ट्रस्ट स्टेट अंडर रे होल्ड करचंती they cannot accept any title from any foreign country without the presidential consent, and no citizen or foreigner holding the office of profit under the state can accept present emolument or office from under foreign states without the presidential consent. Okay, again president consent बिना कौनसी citizen की foreigner who is holding a office of profit or trust under the state can accept any present emolument or office from foreign governments. Okay, and Supreme Court in Balaji Raghavan case 1996 upheld the validity of national awards, the Bharat Ratna, Padma Vibhushan, Padma Bhushan. Okay, these awards do not amount to titles under Article 18. Article 18 ର title जो कहरा हिची titles they are the hereditary nobility titles like Maharaja, Rai Bahadur, Diwan Bahadur. Okay, यही सब टाइटल गुड़ा abolish करा हिची. Okay, बाकी तमरो आर्टिकल बाकी तमरो जो national awards गुड़ा they are not titles under the meaning of Article 18. Okay, but those title holders cannot use these titles as prefix or suffix in their name. Okay, if violated, the award may be forfeited. Okay, so Sachin Tendulkar has got Bharat Ratna, but he cannot say that I am Bharat Ratna Sachin Tendulkar. Okay, सेमती कहले तांकर टाइटल को फॉरफिट कर दिया जीवो. Okay, now नेशनल अवार्ड्स टिके हिस्ट्री एटा क्वेश्चन आसला यूपीएससी रे इंस्टीट्यूट कराइतला 1954 रे डिसकंटिन्यू कराइतला 1977 रे मोरारजी देसाई गवर्नमेंट and it was revived again in 1980 by Indira Gandhi government. Okay, so this much. Now article 19 to 22 right to freedom. Okay, this section is about right to freedom under article 19 to 22. Article 19 6 freedoms are given to citizens. Originally 7 freedom deyitla, but right to property was removed by the 44th Constitutional Amendment Act and it was made a legal right under article 300A. Okay, so please note this fact. Article 19 1 F रे तमरा आगु right to property थिला but एबे repeal कर दिया हला. Supreme Court said that fundamental rights under Article 19 and 21 can also be enforced against private parties and not just state. Okay, so these are freedom that cannot be curtailed by the state as well as private parties. Okay, restriction only on grounds of restriction जोटा सब reasonable restriction को है जी under Article 19 clause 2 रो 19 clause 6. Okay, 19 clause 2, 19 clause 3, 19 clause 4, 19 clause 5 or 19 clause 6, these are they provide the restrictions under the restriction to the freedoms provided in Article 19 clause 1. Okay, Article 19 clause 1 रे A B C D E F एमती सब freedom गुड़ा दिया है जी. Okay, so grounds for reasonable restriction under Article 19 clause 2 तमरा फर्स्ट कॉन्स्टिट्यूशन अमेंडमेंट 1951 रे Article 19 clause 2 रे तमरा तीनटा कंडीशन प्रोवाइड करा गला that can be cause for reasonable restriction. Okay, for freedom of speech and expression. Okay, so ये तीनटा दिन से ऐड करा गला इटा मने रखिबो. So friendly relation with foreign states, incitement to an offence and public order, यही तीनटा को मेंटेन करिया पई तमरा freedom of speech and expression को कटल करी हबो. Okay, so note this, and this was added under first constitutional amendment 1951. Sovereignty and integrity of India was added as a condition in 16th constitutional amendment 1963. Other conditions are defamation, contempt of court, security of state and decency or morality. Okay, so these are the grounds for reasonable restrictions. Article 19 1A, freedom of speech and expression. Supreme Court has said that right to propagate one's views and the views of others come under freedom of circulation. Also, this is a part of freedom of speech and expression. बाकी सब freedom of speech and expression, freedom of press, of commercial advertisement, against phone tapping and telephonic conversation, right to telecast. Government has no poly on electronic media. Right against bond called by a political party or organization, right to know about government activities. So RTI is a can also be called a fundamental right also. Okay, so fundamental right भी तो कही होनी because तार भी बहुत गुड़े अच्छी जे public authority to ही information मागी हबो, but RTI रा backbone माने freedom of speech and expression पाई तमरा right to know is a fundamental right, can be included as a fundamental right. Okay, freedom of silence, this is also a type of expression. Okay, expression of your thoughts. Right to fly the national flag, type of expression of your thoughts. Right of voters to know about the antecedent of election candidates. Right to choose the medium of instruction at primary school. Right to express gender identity. Right to reply to answer to criticism. Right to post information or videos on internet and social media. Right of filmmaker to exhibit films. Right against pre-censorship. Right to access the internet. Okay, for information access. Right to demonstration or picketing, but not the right to strike. Okay, तमें demonstration कर पारिबो, but right to strike सेमती किछ नाही. This right to strike can be governed by the industrial laws. Okay, right to access to internet is also right under freedom to speech and expression. Okay, so please note that right to access to internet is a right, but not the right to fast internet. Okay, so this is a technicality, just I wanted to know, I wanted to share. Okay, now article 19(1)(b), freedom of assembly, right to hold public meeting, procession and demonstration, peaceful or unarmed on public land. This excludes right to association, excludes the violent or riotous assemblies and right to strike. Okay, so restriction under article 19 clause 3, if the assembly violates the sovereignty and integrity of India or public order, then it can be restricted. Statutory provisions, section 144 CRPC, magistrate may restrain assemblies for public safety, health and tranquility. Eta COVID-19 रे यूज कराइला. And section 141 of IPC, unlawful assembly of 5+ persons with objectives like resisting the law, forcible property occupation, criminal trespass or threatening government officials. Okay, this can be restricted. These are statutory provisions that can restrict right to assembly. 19(1)(c), article 19(1)(c), freedom of association, right to form association, union, cooperatives, or okay, like political parties, trade union, societies, club, farm company. It includes a negative right. Okay, right not to join also. Okay, that is also your right not to join. So freedom of association 19(1)(c), एथिरे तमरा also right to form cooperative societies is also a right under 97th constitutional amendment रे, तो एटा तुमको right दिया गला. Now restrictions, restriction to freedom of association under 19 clause 4, sovereignty and integrity of India, public order and morality. Supreme Court ruled that no fundamental right to there is no fundamental right to recognition of association. तमे फॉर्म कर पारिबो बट से recognize हबो तम association सेमिति किछि right नहीं. Trade union are not, there is no guaranteed right to effective bargaining. Okay, जदि trade union करिवो तमे bargaining करिवो सेटा तमरो bargaining टा successful accept हबो कि नहीं, that is not a right. You can form a union but bargaining is not the right, not a fundamental right. No right to strike or lockout. Okay, strike or lockout can be regulated by industrial laws. Okay, article 19(1)(d), freedom of movement within India, citizens can move interstate and intrastate. There are restrictions given under article 19(5), restriction to public interest and protection of ST interest. Okay, जेम तमरो नॉर्थ ईस्ट एरिया रे इनर लाइन परमिट दरकार हुए तुमको सेठे जीवा पई. Okay, तो that restricts your freedom of movement within India. Okay, these restrictions are covered under article 19 clause 5. Supreme Court has said that the movement of prostitutes can be restricted for public health or morals. Okay, and internal freedom article 19 versus external freedom article 21 रे गोटे जिनस एटा गोटे मार्क करिवो तमर article 21 रे that is a right to move abroad. Okay, this is also a fundamental right to life and liberty under article 21, right to move abroad. Okay, article 19 provides internal freedom, article 21 deals with external freedom. Article 19(1)(e), freedom of residence, any individual has the right to reside and settle anywhere in India. Okay, temporary stay or permanent stay. Aim is to remove internal barriers, promote unity and integrity. Restriction under 19(5), public interest, protection of ST interest. Okay, तमरो नॉर्थ ईस्ट एरिया की शेड्यूल एरियाज रे तमे जाएंगी जगह किनी परिबोनी कि रही परिबोनी. Okay, so because that is done to protect their unique culture. Supreme Court has said that certain areas can be barred for prostitutes and habitual offenders for the sake of public order and morality. Okay, 19(1)(g), freedom of profession, occupation, trade and business. So 1(g) बहुत wide scope अच्छी. Any lawful livelihood activity can be practiced by individuals. However, there can be restrictions under 19 clause 6. State may prescribe qualification for certain professions. Okay, तुम right to profession अच्छी तो कहो मो डॉक्टर हेबाकु चाहूँची, but state can provide certain qualification for the profession of a doctor. Okay, again state can carry on trade, industry and service monopoly also. Okay, in partial or complete exclusion to citizens. Okay, तो जमती तमरा एटॉमिक एनर्जी. ओके, न्यूक्लियर फिशन की न्यूक्लियर बम उपरे स्टेट रो मोनोपोली रही. ओके, प्राइवेट सेक्टर को पूरी दौनी स्टेट. ओके, सो प्राइवेट सेक्टर कैन नॉट से दैट तुमरो फ्रीडम ऑफ प्रोफेशन एथरे वायोलेट हला. ओके, स्टेट हैज द मोनोपोली टू कैरी ऑन एनी इंडस्ट्री with partial or complete exclusion of citizens. So this right to freedom of trade and business does not cover immoral or dangerous trades like gambling, human trafficking, okay, drugs trafficking की weapon smuggling. Okay, ये सब immoral की dangerous trade cover करेनी. State can regulate this via licensing and prohibitions. Okay, so these are the these are the article 19 articles: freedom of speech and expression under article 19 clause 1 subclause A, freedom to assemble peacefully under article 19 clause 1 subclause B. एगुड़ा मन रखिबो 1A कोटा B कोटा एगुड़ा मन रखिले बेटर. ओके. फॉर्म एसोसिएशन और यूनियंस अंडर 19 clause 1 subclause C. ये एसोसिएशन और यूनियन रे तमरो राइट टू फॉर्म कोऑपरेटिव सोसाइटीज. Okay. Freedom to move freely throughout India 19(1)D. Freedom to reside anywhere or reside and settle anywhere 19(1)E. तमरो article 19(1)F has been that is the right to property that has been repealed with the 44th Constitutional Amendment Act of 1978. Okay. Now freedom to practice any profession or trade article 19(1)G. Okay. F टा repeal हो जाइए बाकी A रू G. Okay. So these are the six freedoms. Okay. Now we will move to article 20. Now comes article 20 of the Constitution. Article 20 is about protection in respect of conviction for certain offences. तो गोटे जिनस आम ऑलरेडी भी देखीजे fundamental right that are available to only citizens and those that are available to citizen plus foreigner. Article 14 now article 20 रो 28 are available to both citizen as well as foreigners. Okay. को जगह रे enemy alien मानक पई exception थिबो but article 20 रो 28 is also available to both citizen and foreigner. Article 20 is about protection in respect of conviction for certain offences. So protection against arbitrary and excessive punishment, it applies to both citizens and foreigners and legal persons also. Legal person माने company, corporation, everyone सब legal persons. Okay. Non-living persons, they are persons in the eye of the law. तीनटा protection अच्छी article 20 रे. No ex post facto law, आउटे अच्छी no double jeopardy, आउटे अच्छी no self incrimination. तीनटा का law अच्छी article 20 रे. No ex post facto law means no retrospective application of law. नो रेट्रोस्पेक्टिव एप्लिकेशन माने गोटे सपोज गोटे टाइम रे सपोज गोटे ऑफेंस होईची हला सेही टाइम रे से ऑफेंस कंसीडर करा हो नथला अकॉर्डिंग टू लॉ परे किछि टाइम परे गोटे लॉ तयारी करा गला एई लॉ रे एई ऑफेंस एई एक्शन टाकू एज अ ऑफेंस कंसीडर करा गला. ओके. तो जेहेतु एक्शन टा आगुरु हो जाइए लॉ हेबा पूर्व तो दैट इज ए रेट्रोस्पेक्टिव एक्शन. ओके. सो नो पेनाल्टी फॉर एन एक्ट दैट वाज नॉट एन ऑफेंस एट द टाइम ऑफ कमिशन ऑफ दैट ऑफेंस और एट द टाइम ऑफ कमिशन ऑफ दैट एक्शन. ओके. सो दैट इज नो रेट्रोस्पेक्टिव एप्लिकेशन ऑफ लॉ. ओके. So no higher penalty than what was in force when the offence was committed. जदि भी सही टाइम रे जो टाइम रे एक्शन टा कमिट हला सही टाइम रे जदि सही एक्शन पई किछि कोटा पेनाल्टी डिटरमाइन करा हिची आ फ्यूचर रे सही एक्शन पई पेनाल्टी बढ़ाई दिया हिची तो फ्यूचर रो इंक्रीज्ड पेनाल्टी विल नॉट अप्लाई टू द एक्शन डन इन पास्ट. ओके. सो नो हायर पेनाल्टी देन व्हाट वाज इन फोर्स व्हेन द offense was committed and it applies only to criminal laws and not civil laws or tax laws. Okay. तब जदि तुम पास्ट रे किसी सिविल की टैक्स फ्रॉड करछ ओके सपोज टैक्स किसी फ्रॉड करछ आउ परे दैट एक्शन इज कंसीडर्ड एज एन ऑफेंस देन न्यू लॉ कैन बी अप्लाइड on the on your previous action. Okay. So it applies only to criminal laws and not civil laws or tax laws. It is not available in case of preventive detention or security demands. Okay. So एटा भी गोटे जिनस मन रख ये जो पेनाल्टी और कन्वेंशन ये जो पेनाल्टी और कन्विक्शन जोटा सो दीज आर नॉट एंकर जहाँ भी सपोज ट्रायल जोटा हम दैट कैन बी डन अंडर न्यू लॉ फॉर एन एक्ट कमिटेड इन द पास्ट. ओके. तो ये सब जहाँ भी समय प्रोटेक्शन पड़े जदि सपोज पास्ट रे से एक्शन टा किसी क्राइम नथिला ऑफेंस नथिला फ्यूचर रे से एक्शन टा को क्राइम भाबे कि ऑफेंस भाबे डिक्लेयर करा गला. ओके. तो एबे नुआ लॉ हिसाब रे ट्रायल करा जे परिबो. ओके. ट्रायल इज अलाउड अंडर न्यू लॉ for the offense committed in the past, but conviction cannot be retrospective. ओके सो प्लीज नोट दिस टेक्निकालिटी तुम ट्रायल नुआ लॉ रे पारे बट कन्विक्शन पुराना नुआ लॉ हिसाब रे हबनी ओके ट्रायल हो पारे नुआ लॉ हिसाब रे तो आउ गोटे जिन देख ये बहुत टाइम आम क्रिमिनाल लॉ और सिविल लॉ ये जिनटा बारंबार आसो तो ये ही देखिए सिविल लॉ कौन क्रिमिनाल लॉ कौन ओके तो सिविल लॉ केस रे कौन हुए फास्ट तो हूँ तुम स्टेट ओके स्टेट नो जुडिशियरी जुडिशियरी पाखे दीटा पार्टी अच्छा सपोज पार्टी 1 एंड पार्टी 2 सपोज पार्टी 1 इज द अक्यूज्ड एंड पार्टी 2 इज द विक्टिम ओके तो सिविल केस रे कौन हुए तो यही दी जन भितर किसी गोटा एग्रीमेंट हुए दैट अक्यूज्ड विल गिव सम कंपेंसेशन टू द विक्टिम मोस्टली इट इज इन केस ऑफ मॉनेटरी कंपेंसेशन और प्रॉपर्टी कंपेंसेशन ओके सो जुडिशियरी विल डिसाइड पार्टी 1 पार्टी 2 को केते कंपेंसेशन दब ओके दैट इज सिविल लॉ दैट इज सिविल केसेस सिविल केस रे दी जन भितर अक्यूज्ड जे विक्टिम किसी कंपेंसेशन दब क्रिमिनाल केस रे कौन हुए तुम अक्यूज्ड अच्छी विक्टिम अच्छी तो अक्यूज्ड जेहेतु से क्रिमिनाल एक्टिविटीटा करी तो जुडिशियरी और द स्टेट विल पनिश द अक्यूज्ड ओके विल पनिश द अक्यूज्ड सी अक्यूज्ड किसी कंपेंसेशन दे पारे न दे पारे बट द स्टेट और जुडिशियरी विल पनिश द अक्यूज्ड फॉर कमिटिंग ए क्रिमिनाल एक्ट से जिनटा सिविल केस रे नहीं सिविल केस रे जुडिशियरी की स्टेट अक्यूज्ड को पनिशमेंट दबनी ओके या भितर किसी बुझाणा हम बट अक्यूज्ड को पनिशमेंट दिज्व क्रिमिनाल केसेस रे नॉट इन सिविल केसेस सो दैट इज द बेसिक डिफरेंस बिटवीन सिविल केस एंड क्रिमिनाल केस ओके नाउ यहाँ आम देखिले नॉट अवेलेबल इन केस ऑफ प्रिवेंटिव डिटेंशन ओके सो दिस नो रेट्रोस्पेक्टिव एप्लिकेशन ऑफ लॉ यहाँ तुम प्रिवेंटिव डिटेंशन केस रे तुम रेट्रोस्पेक्टिव एप्लिकेशन हो पार एंड इन सिक्योरिटी डिमांड्स ओके सिक्योरिटी डिमांड्स माने कौन सिक्योरिटी डिमांड्स माने कौन जे एट टाइम्स मान जो मैंने अथॉरिटी मैंने अच्छा से मैंने गोटे पोटेंशियल सस्पेक्ट को गोटे बॉन्ड कि किसी गोटे सपोज फाइनेंशियल गारंटी साइन करांती दैट पर्सन और सस्पेक्ट विल मेंटेन पब्लिक पीस और गुड बिहेवियर फॉर ए स्पेसिफिक पीरियड ओके तो से जी सस्पेक्ट सी गोटे सिक्यूरीटी दब अथॉरिटीज मानक जे मु किसी खराब बिहेवियर करिविनी किसी समय पाई ओके सो दैट एक्ट्स लाइक ए प्रिकॉशन टू डेटर दी सस्पेक्ट फ्रॉम एंगेजिंग इन डिस्ट्रप्टिव बिहेवियर ओके सो से सिक्यूरीटी रे ही तुम डेटर लिखाई जे प्रोस्पेक्टिव की रेट्रोस्पेक्टिव एप्लिकेशन ऑफ लॉ से जिनटा तुम सिक्यूरीटी रे ही मेंशन कराई ओके तो सिक्यूरीटी डिमांड फॉर सिक्यूरीटी फ्रॉम दी सस्पेक्ट कैन बी एक्सक्लूडेड फ्रॉम रेट्रोस्पेक्टिव लॉ ओके सेटा से सिक्यूरीटी रे ही मेंटेन कराई आउ प्रिवेंटिव डिटेंशन केस रे भी रेट्रोस्पेक्टिव लॉ इज नॉट अवेलेबल इन केस ऑफ प्रिवेंटिव डिटेंशन नाउ no double jeopardy means no person shall be prosecuted and punished twice for the same offence okay so article 20 clause 2 says about no double jeopardy it applies only to judicial proceedings that is court case ki tribunal case judicial proceeding it is not applicable to departmental or administrative inquiries okay because these departmental and administrative inquiries are non judicial in nature तो एथिरे कौन हम सपोज गोटे डिपार्टमेंट तुम उपर जदि किसी गोटे पेनाल्टी लगे तुम चाहिए से ऑफेंस आउ गोटे डिपार्टमेंट आउ थे पनिशमेंट दे पार ओके so that can be done in departmental and administrative inquiry but not in judicial proceeding no self incrimination under article 20 clause 3 no self incrimination no accused person can be compelled to be witness against himself okay witness against himself means they cannot be compelled to produce oral and documentary evidence okay but this applies only to criminal proceedings and not civil proceedings तो civil case रे the accused can be compelled to produce documents that prove that are evidence against themselves okay civil case रे एटा applicable नुह केवल criminal proceedings case रे okay because criminal proceedings are severe in nature सेतरे state तुम punishment दबो तो सेतरे state रही duty to find these documents okay not in civil cases and this no self incrimination does not cover compulsory production of material object गिविंग थंब इम्प्रेशन और ब्लड सैंपल्स एंड एक्जिबिशन ऑफ बॉडी ओके तो जदि गोटे क्रिमिनाल कह मु सपोज मो डीएनए सैंपल देबेनी कि हेयर सैंपल देबेनी कि डीएनए सैंपल देबेनी सो से जिन गुड़ा कवर नुह ऑन नो सेल्फ इंक्रिमिनेशन से जिन गुड़ा कवर नुह ओके सो यहाँ गला तुम आर्टिकल 20 क्लॉज 3 नाउ आर्टिकल 21 प्रोटेक्शन ऑफ लाइफ एंड पर्सनल लिबर्टी सो no person shall be deprived of his life and personal liberty except according to the procedure established by law एटा आर्टिकल 21 स्टेटमेंट सो नो पर्सन जेहतु देखाई पर्सन माने इट इंक्लूड्स बोथ सिटीजन एंड नॉन सिटीजन सो दुईटा जिनस प्रोसीजर एस्टाब्लिश्ड बाय लॉ और ड्यू प्रोसेस ऑफ लॉ ये जिनसटा एबे देखिदवा एटा बहुत थर एग्जाम रे आछि व्हाट इज प्रोसीजर एस्टाब्लिश्ड बाय लॉ एंड ड्यू प्रोसेस ऑफ लॉ ओके तो ये जिनसटा कौन देखिदवा तो गोटे जिनस व्हाट इज द ड्यू ऑफ लॉ लॉर ड्यू कौन ओके ड्यू ऑफ लॉ इज टू गिव जस्टिस ओके नोट दिस ड्यू ऑफ लॉ इज टू गिव जस्टिस जदि गोटे लॉ अच्छी बट जस्टिस दे पारुनी देन दैट शुड नॉट बी कंसीडर्ड एज अ लॉ ओके सो दिस इज द प्राइमरी आइडिया प्रोसीजर एस्टाब्लिश्ड बाय लॉ एटा जापान कॉन्स्टिट्यूशन अणाई ता माने जदि गोटे लॉ प्रोसीजर देकी फॉर्म होइछि देन द अथॉरिटी ऑफ द लॉ कैन नॉट बी क्वेश्चनड ओके जदि पार्लियामेंट रे हाँ लॉ प्रपोज हला बिल आसिला तार भोटिंग हला भोटिंग पर प्रेसिडेंट एक्सेंट कले तापर लॉ हो गला तेनिक से लॉ जहाँ भी हो से जस्टिस हो न हो डजंट मैटर जस्टिस न हेले भी जेहेतु से प्रोसीजर फॉलो करछि देन दैट लॉ इज वैलिड ओके से जस्टिस हो न हो इट डजंट मैटर बट ड्यू प्रोसेस को लॉ शुड प्रोसीजरल ड्यू प्रोसेस ओके प्रोसीजरल ड्यू प्रोसेस से प्रोसीजर ठीक देकी आसी प्लस सब्सटेंशियल ड्यू प्रोसेस मीन्स द सब्सटेंस ऑफ द लॉ शुड ऑल्सो बी राइट ओके सब्सटेंस ऑफ द लॉ शुड ऑल्सो प्रोवाइड जस्टिस बिकॉज ड्यू ऑफ लॉ इज टू प्रोवाइड जस्टिस ओके तो ड्यू ऑफ लॉ जो ड्यू प्रोसेस ऑफ लॉ जस्टिस को इंश्योर करे प्रोसीजर एस्टाब्लिश्ड बाय लॉ मे भी जस्टिस को इंश्योर करि पारे न करि पारे ओके तो ये प्रोसीजर एस्टाब्लिश्ड बाय लॉ रे तुम एडमिनिस्ट्रेशन को एडमिनिस्ट्रेटर ये जो लेजिस्लेचर को बहुत अथॉरिटी मिल जाए लेजिस्लेचर खाली जस्ट लॉ पास करदेले तार काम सरला ओके नो वन कैन चैलेंज दैट लॉ ओके बट ड्यू प्रोसेस रे जदि लेजिस्लेचर प्रोसीजर फॉलो करछि बट जदि से लॉटा जस्टिस को हैम्पर करछि देन दैट लॉ कैन बी नलिफाइड ओके तो जोटी प्रोसीजर ड्यू प्रोसेस सेठी लेजिस्लेचर और पार्लियामेंट इज पावरफुल ड्यू प्रोसेस रे हु विल डिसाइड वेदर द लॉ इज प्रोवाइडिंग इट्स ड्यू और द लॉ इज प्रोवाइडिंग जस्टिस दैट इज जुडिशियरी सो ड्यू प्रोसेस रे जुडिशियरी इज पावरफुल बिकॉज जुडिशियरी विल डिसाइड वेदर द लॉ satisfies the condition of due process of law okay so एटा होची तमरो बेसिक कांसेप्ट तो procedure established by law it is Japanese in origin law cannot be questioned for being unjust or unfair जदि procedure follow करा हिची then it cannot be questioned due process law is an American concept where it ensures that law is not only present but also fair just and reasonable एटा from the due process of law also comes from the school of natural justice मैं ऑलरेडी तुम प्रिएम्बल सेशन रे कहिछि व्हाट इज नेचुरल जस्टिस इट बिलोंग्स टू द स्कूल ऑफ नेचुरल जस्टिस प्रोसीजर एस्टाब्लिश्ड बाय लॉ स्कूल ऑफ पॉजिटिव लॉ एटा मैं कहि दिछि ऑलरेडी प्रिएम्बल आई थिंक प्रिएम्बल्स वीडियो रे मैं कहि दिछि एक्सप्लेन कर दिछि स्कूल्स ऑफ लॉ ओके ए दिटा गला प्रोसीजर एस्टाब्लिश्ड बाय लॉ एंड ड्यू प्रोसेस लॉ ऑफ लॉ इंडिया रे केमते एवोल्यूशन हेतला अबाउट दिस टू डॉक्ट्रिन्स अंडर आर्टिकल 21 तो ए.के. गोपालन केस 1950 रे ए.के. गोपालन ही वाज ए कम्युनिस्ट लीडर एंड ही वाज ए फ्रेंड ऑफ जवाहरलाल नेहरू बट नेहरू पुट हिम इन जेल तापरे तांको केस रे डिसाइड करागला सुप्रीम कोर्ट डिसाइड कला जे आर्टिकल 21 प्रोटेक्ट्स ओनली फ्रॉम एग्जीक्यूटिव एक्शन एंड नॉट लेजिस्लेटिव एक्शन ओके बिकॉज आर्टिकल 21 रो टेक्स्ट रे लिखा हिजी नो पर्सन शैल बी डिप्राइव्ड ऑफ लाइफ एंड लिबर्टी एक्सेप्ट अकॉर्डिंग टू प्रोसीजर एस्टाब्लिश्ड बाय लॉ ओके ड्यू प्रोसेस ऑफ लॉ तो लिखा ही नहीं तो सुप्रीम कोर्ट टुक द नारो इंटरप्रिटेशन ऑफ आर्टिकल 21 एंड सेड दैट आर्टिकल 21 प्रोटेक्ट्स ओनली फ्रॉम एग्जीक्यूटिव एक्शन एंड नॉट लेजिस्लेटिव एक्शन लेजिस्लेटिव जहाँ भी जदि प्रोसीजर फॉलो करछि ताहले एग्जीक्यूटिव से जिनस करिया बाध्य एग्जीक्यूटिव ता मन इच्छा एक्शन कर परिबोनी सो आर्टिकल 21 प्रोटेक्ट्स ओनली फ्रॉम एग्जीक्यूटिव एक्शन executive has to follow the law made by the legislature. Okay, and this law and this article 21 is not a deterrent to legislature, because if the procedure has been followed, then there is no issue in the law. So Supreme Court said that personal liberty means liberty related only to the body of the person. Okay, that is the personal liberty. This is the interpretation of liberty done by Supreme Court in the A.K. Gopalan case. तापर मेनका गांधी केस रे तमरो सुप्रीम कोर्ट एक्सपांडेड इट्स व्यू. सुप्रीम कोर्ट डिड लिबरल इंटरप्रिटेशन ऑफ आर्टिकल 21. ओके, सो सुप्रीम कोर्ट सेड दैट आर्टिकल 21 रे जो प्रोटेक्शन अच्छी टू लाइफ एंड लिबर्टी, इट इंक्लूड्स द प्रोटेक्शन अगेंस्ट बोथ एग्जीक्यूटिव एंड लेजिस्लेटिव आर्बिट्ररीनेस. ओके, so law must be reasonable, fair and just, that is due process of law, and right to life also includes the right to live with dignity, and personal liberty widest amplitude covering multiple rights. Okay, so Supreme Court in the Menka Gandhi case has done liberal interpretation of this provision. No person shall be deprived of life or personal liberty. Liberal interpretation means Supreme Court has expanded this meaning of life and personal liberty in the Menka Gandhi case. Okay, and has introduced due process of law in the working of India. Okay, so एटा गला तुम प्रोसीजर एस्टाब्लिश्ड बाय लॉ, ड्यू प्रोसेस ऑफ लॉ. इधर क्वेश्चन बहुत थोड़ा आछि हमर ओसीएस 2023 रे आछि. व्हिच आर द फॉलोइंग स्टेटमेंट्स आर करेक्ट विथ रिस्पेक्ट टू ड्यू प्रोसेस ऑफ लॉ एंड प्रोसीजर एस्टाब्लिश्ड बाय लॉ. ड्यू प्रोसेस ऑफ लॉ फोकस ऑन द फॉर्मल एडहेरेंस टू लीगल प्रोसीजर्स सेट बाय द गवर्नमेंट. इट एक्चुअली प्रोसीजर एस्टाब्लिश्ड बाय लॉ. सो स्टेटमेंट 1 इज रॉन्ग. Procedure established by law emphasizes the protection of individual rights and fairness in the application of law and legal proceeding. So this is due process of law. So again this is also wrong. So both 1 and 2 are not correct. Okay, so I think it has all about procedure established by law and due process of law. अब से जो meaning of life and liberty तमरो केएस पुट्टास्वामी केस रे भी privacy was construed to be a natural right under Article 21. Okay, right to privacy was a natural right under Article 21, and this privacy can be restricted only if the state ro gote purpose अच्छी legitimate purpose. Okay, state रो गोटे legitimate purpose अच्छी and से purpose को achieve करने ପାଇଁ गोटे legal mandate अच्छी state पाखे आउ से पर्पस को अचीव करने लीगल मैंडेट अच्छी. और जहाँ भी स्टेट एक्शन नब दैट एक्शन शुड बी प्रोपोर्शनेट एक्शन. ओके, प्रोपोर्शनेट एक्शन मीन्स इट इज नॉट एक्सेस एज कंपेयर टू दी गोल टू बी अचीव्ड. बिकज जदि गोल अचीव करने जदि किसी आउटे कम सिवियर एक्शन नवा पड़ो देन दैट शुड बी टेकन, नॉट दी मोस्ट सिवियर और हार्सेस्ट ऑफ द एक्शन. ओके, सो दीज आर दी दिस इज द रूलिंग इन केएस पुट्टास्वामी केस. तुम हादिया केस रे भी तुम Supreme Court कही that right to marry a person of one's own choice is integral to Article 21 under right to life. MK Ranjit Singh judgment এই কেসটা important because এই বর্ষ হি হইছি. It recognized the right to protection from climate change impact under Article 21 and Article 14. So this right to be free from the adverse effect of climate change was recognized as a fundamental right under Article 21. Okay, तो ये केस रे कौन होता तुम जो ग्रेट इंडियन बस्टार्ड अच्छी तुम राजस्थान रे ग्रेट इंडियन बस्टार्ड गोटे PIL फाइल कराइला टू कंजर्व ग्रेट इंडियन बस्टार्ड. ओके, तो से सुप्रीम कोर्ट ये जजमेंटा देते फंडामेंटल राइट टू बी फ्री फ्रॉम एडवर्स इंपैक्ट ऑफ क्लाइमेट चेंज इज इंक्लूडेड अंडर आर्टिकल 21. ओके, नाउ आर्टिकल 21 ए राइट टू एजुकेशन. Right to education, it was inserted by the 86th Constitution Amendment Act 2002. ये जिनसा मन रख, एटा बहुत इंपोर्टेंट और बहुत प्रिलिम और मेंस रे भी यूज करिवो एटा. सो आर्टिकल 21 रे कहि स्टेट शैल प्रोवाइड फ्री एंड कंपलसरी एजुकेशन टू ऑल चिल्ड्रेन एज 6 to 14 years. Okay, 6 to 14 years elementary education in a manner as the state may by law determine. Okay, right to education is a fundamental right under Article 21A. So scope only elementary education that is 6 to 14 years is fundamental right, does not cover higher or professional education. And Right to Education Act 2009 was enacted to implement the Article 21A. Okay, 86 Constitutional Amendment Act रे तमरा 21A इंसर्ट करागला. 21A को इफेक्ट देवाई राइट टू एजुकेशन एक्ट 2009 आसिला. ओके, जुडिशियल रिकग्निशन उन्नी कृष्णन केस 1993 रे सुप्रीम कोर्ट रिकग्नाइज दी फंडामेंटल राइट टू प्राइमरी एजुकेशन एज अ राइट टू लाइफ अंडर आर्टिकल 21. ओके, तो बहुत आगु 1993 रे भी सुप्रीम कोर्ट हैज रिकग्नाइज दी फंडामेंटल राइट टू प्राइमरी एजुकेशन एज part of right to life under Article 21. 86th Constitution Amendment significance, it is described as the dawn of second revolution in the chapter of citizens' rights. Okay, so dawn of second revolution tomorrow tale first revolution is the inclusion of fundamental right in the original constitution in 1950s. Okay, so that is the first revolution, and 86th Constitution Amendment Act को कहा जाए dawn of second revolution in the chapter of citizens' rights. Okay, please note ए जिनसटा पी मे भी पचार दी पारंती. ओके 86 CAA रे आर्टिकल 45 पे भी चेंजेस करागला DPSP. इट चेंज द मैंडेट टू स्टेट्स आर एंडेवर टू प्रोवाइड अर्ली चाइल्डहुड केयर एंड एजुकेशन अंटिल 6 इयर्स. ओके, तो आगु कौन थी आर्टिकल 45 रे थिला स्टेट्स आर प्रोवाइड एजुकेशन टू चिल्ड्रेन ऑफ 6 to 14 इयर्स. ओके, तो 86th अमेंडमेंट रे 6 to 14 इयर्स टाको आर्टिकल 21A को निया जाइगला आउ 45 को चेंज कर दिया गला अबाउट अर्ली चाइल्डहुड केयर एंड एजुकेशन फ्रॉम 0 to 6 इयर्स. ओके, तो जो आंगनवाड़ी प्री स्कूल एजुकेशन एटा इट इज ए DPSP. आउ आर्टिकल 51A को भी इंसर्ट करागला इन सॉरी इंसर्ट नो अमेंड करागला इन फंडामेंटल ड्यूटीज जेतर गोटे आर्टिकल 51(1)(k). ओके, सॉरी आर्टिकल 51A क्लॉज सब क्लॉज K एटा इंट्रोड्यूस करागला दैट सेड दैट एवरी सिटीजन मस्ट प्रोवाइड एजुकेशन टू चाइल्ड बिटवीन 6 to 14 इयर्स. ओके, एटा गोटे फंडामेंटल ड्यूटी हिसाब रे इंसर्ट करागला इन 86th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट. ओके, सो तुमर राइट टू लाइफ एंड लिबर्टी जेहेतु आई हैव सेड कि सुप्रीम कोर्ट डिड लिबरल इंटरप्रिटेशन ऑफ राइट टू लाइफ एंड लिबर्टी इन द मेनका गांधी केस. सो it has declared the following items as right to as part of right to life under Article 21. तो बहुत गुड़े राइट सुप्रीम कोर्ट इंट्रोड्यूस कर लाइक राइट टू लिव विथ डिग्निटी. ओके, राइट टू लाइवलीहुड, प्राइवेसी, शेल्टर, हेल्थ. ओके, एटा सब तुम देखिए एगेंस्ट सॉलिटरी कन्फाइनमेंट एटा गोटे इंटरेस्टिंग राइट. राइट टू स्पीडी ट्रायल, एगेंस्ट हैंड कफिंग. ओके, राइट टू ट्रावेल अब्रॉड ये जिनसा मन रख इट इज ऑल्सो ए राइट पार्ट ऑफ राइट टू लाइफ. एंड राइट अगेंस्ट बॉन्डेड लेबर आउ जहाँ भी सब अच्छी. ओके, राइट टू स्लीप एटा गोटे राइट. राइट टू डाई विथ डिग्निटी दैट इज पैसिव यूथेनेसिया. ओके, सो ये सब थिला तमर इट इज ऑल अबाउट आर्टिकल 21. ओके, नाउ आर्टिकल 22 protection in case of arrest and detention. So there are two types of detention, one is preventive and another is punitive detention. Preventive detention without trial and conviction detain kara jaye, punitive re after trial and conviction. Article 22 clause 1 deals with right of persons arrested under ordinary law. Okay, again these provisions jaha bhi 22(1) ro under ordinary this is under ordinary criminal law. ओके, क्रिमिनल लॉज आर वेरी सिवियर दैट्स वाई सब जगह क्रिमिनल लॉ रही प्रोविजन स्पेसिफाई कराई, नॉट सिविल लॉ और टैक्स लॉ दैट इज सिविल लॉ. ओके, सो आर्टिकल 22 clause 1 deals with provision applicable to only criminal cases. Okay, and even also 22(1) रे भी ordinary law or not civil law plus if the person is disrupting public interest, okay, hampering public interest, then also these provisions can be applied. Okay, so 22 clause 1 right to be informed of grounds of arrest. जे अरेस्ट है ताको जना जीव कौन पाई अरेस्ट होइछि. राइट टू कंसल्ट एंड बी डिफेंडेड बाय लीगल प्रैक्टिशनर. राइट टू बी प्रोड्यूस्ड बिफोर ए मैजिस्ट्रेट विदिन 24 hours एक्सक्लूडिंग द जर्नी टाइम. Okay, and right to be released after 24 hours unless the magistrate authorizes further detention. Okay, these safeguards are not available to enemy aliens and persons under preventive detention law. Okay, enemy alien foreigners को भी एटा available अच्छी but not to enemy aliens. Enemy aliens means foreigners who are declared enemies of the state. Foreigners who belong to a country, that country is declared as enemy of the state. Okay, those are enemy aliens. Next comes Article 22 clause 2 deals with safeguards regarding preventive detention. Applies to citizens and aliens both. Maximum detention 3 months unless an advisory board approves longer detention time. Okay, advisory board composition it comprises of persons who are or have been or qualified to be appointed as judges of a high court. Okay, please note this, judges of a high court se mane hei paranti kimba or they are qualified to be appointed as judges of the high court. Okay, so Parliamentary role in preventive detention. Parliament can prescribe the circumstance or classes for preventive detention beyond 3 months without the advisory board opinion. Okay, advisory board को न पचारे कि भी 3 मास अधिका भी डिटेंशन जदि करा जीवो ता पई लॉ पार्लियामेंट कर परिबो. मैक्सिमम डिटेंशन पीरियड अंडर प्रिवेंटिव डिटेंशन लॉ. ओके, 3 मास की केते सेटा पार्लियामेंट हाथ प्रोसीजर दैट द एडवाइजरी बोर्ड फॉलोज टू फंक्शन. ओके, and Parliament has the exclusive authority for making preventive detention laws in the domain of defense, foreign affairs and security of India. Okay, so please note, both Parliament and state legislature can make laws, can legislate on preventive detention for security of state, maintenance of public order and supplies and services essential to community. Okay, ये जिनसा मन रख. आउ तमरो डिफेन्स फॉरेन अफेयर्स और सिक्यूरीटी ऑफ इंडिया रे तुम केवल पार्लियामेंट हैज द रोल टू मेक हैज द अथॉरिटी टू मेक प्रिवेंटिव डिटेंशन लॉस. ओके, so please note, no democratic nation in the world has made preventive detention law an integral part of its constitution like India. Okay, also included in part 3 of fundamental rights भितर भी जेतु ए जिनसटा अछि. So this is a criticism of Indian constitution and fundamental rights. Okay, now comes the Article 22 Clause 5 the rights of preventive detainees. Okay, जो माने preventive detention रे arrest हेइचंती detain हेइचंती तांकर rights, they must be informed of the grounds of detention, guaranteed opportunity to make representation against detention. Okay, but again jodi if the authority considers that such informing the detainee of the grounds for which they have been detained or the opportunity to make representation that goes against the public public interest, then the authority can deny these rights also. Okay, so please note, these rights are not absolute. These rights are dependent on the wishes of the authority. Okay, এটা সরলা আমার প্রিভেন্টিভ ডিটেনশন. নাও রাইট এগেনস্ট এক্সপ্লয়টেশন আর্টিকলস 23 ରୁ 24. ওকে, সো 23 prohibition of traffic in human beings and forced labor. So it applies to citizens and not citizens. আমি অলরেডি কইছি 20 ରୁ 28 applies to both citizens and non citizens. So 23 enforceable against state and private persons, both state and private persons. Exception the state can impose compulsory service for public purpose like military or social service. Okay, without any obligation to pay. Okay, that is the prerogative of the state. And traffic in human beings are mane kono, selling and buying of men, women and children like goods, immoral traffic in women and children, prostitution, devdasi system and slavery. Okay, so these are banned. Okay, so tanko ban kariya pai gote immoral traffic prevention act 1956 enact karaitala to punish these acts. Okay, so that is prohibition of traffic in human beings and forced labor. Okay, forced labor also includes the compulsion to work at wages lower than the minimum wages due to economic condition. Okay, जदि तार इकोनॉमिक कंडीशन पाई गोटे लोक बाध्य होची मिनिमम वेजेस रु कम वेजेस रे काम करिया को, दैट इज आल्सो कंसीडर्ड एज फोर्स्ड लेबर. ओके, स्टेट रो ड्यूटी अछि सेही जिनसटा को भी अटकिया पाई. ओके, सो दैट इज ट्रैफिक इन ह्यूमन बीइंग्स एंड फोर्स्ड लेबर. Now Article 24 prohibition of child labor. Okay, so no child below 14 years can be employed in factories, mines and hazardous activities like construction, railway, etc. Okay, but it permits employment in harmless and innocent work. Okay, so that is permitted. Otherwise hazardous activity re no child can be employed below 14 years. Okay, protective measures. Commission for Protection of Child Rights Act 2005 established National Commission for Child Rights and State Commission for Child Rights, and it also established children's courts for speedy trial of offences related to children. Supreme Court has directed the creation of Child Labour Rehabilitation Welfare Fund. Okay, तो Child Labour Rehabilitation Welfare Fund एथरे कौन हुए जो माने सपोज चिल्ड्रेन मान को एम्प्लॉय करती इन हाजरस एक्टिविटी तो तांको पेनालाइज करा जाए से पेनाल्टी अमाउंटा ए फंड रे आसे ए फंड टाको यूज करा जाए फॉर रिहैबिलिटेशन ऑफ द रेस्क्यूड चिल्ड्रेन. ओके, 2006 रे गवर्नमेंट बैन दी prohibition of government banned the employment of children below 14 in domestic service, in hotels, dhabas, restaurants, shops and business establishments. Okay, anyone who employs child below 14 is liable for prosecution and penal action. Okay, a penalty amount ta tamara ei fund ku jae. Okay, so एटा सब गला तमर आ गोटे भी गोटे मेन लॉ रही जाइछि तमर चाइल्ड एंड एडोलेसेंट लेबर प्रोहिबिशन एंड रेगुलेशन एक्ट 1986. ओके, सो चाइल्ड एंड एडोलेसेंट Prohibition and Regulation Act 1986 तमर सेमती Factories Act 1948 ओके यही सबू दे आर ऑल्सो अमेंडेड टू प्रोहिबिट द एम्प्लॉयमेंट ऑफ चिल्ड्रेन ओके गोटे टेक्निकल जिनस गोटे मार्क कर तुम आर्टिकल 24 रे चाइल्ड समवन हु इज बिलो 14 इयर्स ओके बट तुम जुवेनाइल जस्टिस एक्ट रे एथरे तुम डेफिनेशन ऑफ चाइल्ड इज बिलो 14 इयर्स ओके बट तुम जुवेनाइल जस्टिस एक्ट रे डेफिनेशन ऑफ चाइल्ड इज बिलो 18 इयर्स ओके तो ये जिनटा जस्ट गोटे जिनस मार्क करियो नाउ विल मूव टू द नेक्स्ट right to freedom of religion under article 25 and 25 to 28 so 25 is freedom of conscience and religion so freedom of conscience means inner freedom to mold one's relation with God or any creature right to profess practice and propagate any religion okay you can declare your religious beliefs openly you can worship ritualize and ceremonialize your faith you can propagate transmission and disposition of one's religious ideas okay but it does not include the right to convert others because right to convert or forcible conversion they violate the freedom of conscience of other individuals okay so alga individual man ka fundamental right tame encourage kar paribani to satisfy your fundamental right okay so right to convert is not a fundamental right and article 25 covers both religious beliefs and religious practices okay and तमर beliefs philosophies और rituals both को cover करे article 25 okay जेमती तमर wearing or carrying of kirpan by the Sikhs okay this is considered as an essential part of Sikh religion okay so that is one thing and Hindus article 25 रे Hindus include Sikhs Jains and Buddhists also okay so it is available to everyone citizen and non citizen restriction जदि public order morality health और other fundamental right provision in part 3 जदि violate हला then the fundamental rights under article 25 can be curtailed okay तो एटा गला 25 रे तम article 25 clause 2 रे भी तमरा कहै that state can regulate the economic or financial or secular activities okay secular activities that is connected associated with any religious practice okay तो जमती तुम श्री जगन्नाथ टेम्पल एडमिनिस्ट्रेशन ओके सो तार जदि जमती डे टू डे एडमिनिस्ट्रेशन दैट इज ए सेक्युलर एक्टिविटी ओके स्टेट कैन पार्टिसिपेट इन द सेक्युलर एक्टिविटी इन द रेगुलेशन ऑफ ए रिलीजन ओके दैट इज आर्टिकल 25 एवरीथिंग अबाउट आर्टिकल 25 नाउ आर्टिकल 26 फ्रीडम टू मैनेज रिलीजियस अफेयर राइट ऑफ एवरी रिलीजियस डिनोमिनेशन और सेक्शन ओके so any religious denomination can establish and maintain an institution for its religious and charitable purpose can manage its own affairs in the matter of religion own and acquire movable and immovable property administer property in accordance with law okay 25 or 26 with the difference is 25 gives rights to individual religious freedom okay 25 deals with individuals while 26 deals with collective denomination or with institutions 25 deals with individuals okay तो गोटे जिनस देखो 26 रे जो रेस्ट्रिक्शन गुड़ा कही रेस्ट्रिक्शन टू पब्लिक ऑर्डर मोरालिटी एंड हेल्थ एंड नॉट अदर फंडामेंटल राइट प्रोविजन ओके तुमर आर्टिकल 25 रे रेस्ट्रिक्शंस आर सब्जेक्ट टू fundamental right of others but 26 रे it is not subject to fundamental right of others why because article 25 deals with individuals and fundamental rights fundamental rights deals with individuals okay so that's why article 25 रे fundamental right रो restriction अछि article 26 रे नाही okay 25 रे rights of one individual cannot interfere with rights of another individual okay तो सेइत पई 25 रे फंडामेंटल राइट अदर फंडामेंटल राइट रो रेस्ट्रिक्शन अच्छी 26 रे तुम इंस्टीट्यूशन ऑटोनॉमी इंस्टीट्यूशन इज नॉट कनेक्टेड विथ इंडिविजुअल सो दैट्स वाई ये जिनसा तुम 26 रे इंक्लूड करा जाएगी ओके नाउ सुप्रीम कोर्ट रो टेस्ट फॉर रिलीजियस डिनोमिनेशन ओके सुप्रीम कोर्ट ही टेस्ट देजी फॉर ए रिलीजियस डिनोमिनेशन लाइक इट शुड हैव ए कलेक्शन ऑफ डॉक्ट्रिन्स बिलीव्स फॉर स्पिरिचुअल वेलबींग गोटे कॉमन ऑर्गेनाइजेशन थी एंड हैव ए डिस्टिंक्ट नेम तो सही हिसाब से तुम रामकृष्ण मिशन एंड आनंद मार्ग आर रिलीजियस डिनोमिनेशन विद इन द हिंदू रिलीजन ओके विद इन द हिंदू रिलीजन ओके सेमती तुम अरविंद सोसाइटी वाज नॉट ए सेपरेट डिनोमिनेशन आउटसाइड हिंदू रिलीजन ओके तो यहाँ सुप्रीम कोर्ट डिसाइड कर तो यही सब टेस्ट कौटा जिनस गोटे रिलीजन एसेंशियल प्रैक्टिस रे जीव सो से सुप्रीम कोर्ट को क्रिटिसाइज करा जाए दैट इज कॉल्ड जुडिशियल पापाजिम इटा जस्ट मेन्स पॉइंटर जुडिशियल पापाजिम मीन्स जुडिशियरी इज द सुप्रीम प्रीस्ट so judiciary will decide co religion रे कौन हवा कथा ओके so that is criticized by religious groups against judiciary. Now comes article 27 freedom from taxation for promotion of religion. So no person can be compelled to pay taxes to promote or maintenance of any particular religion. Okay jodi this tax can be used for promoting all religion. Okay कौन सी गोटे religion को promote करिया पे state cannot impose tax. Okay so it prevents the state from favoring, patronizing or supporting only one religion, and these provision freedom from taxes apply only to taxes and not to fees. Fees माने fees are the price taken to provide a particular service to pilgrims. So suppose गोटे जदि गोटे पिलग्रिम मैंने आसिले गोटे टेम्पल को विजिट कले सेठी जदि जड़े कह मु फी नौ तुम मोबाइल आ जोता जूता चप्पल पर्स मोबाइल को नहीं मुझे पैसा नेबी आ तुमको तापर तुम मंदिर जापर ओके सो दैट इज नॉट कंसिडर्ड एज अ टैक्स दैट इज ए फी इज प्राइस टेकन टू प्रोवाइड ए पर्टिकुलर सर्विस ओके सच फीज आर अलाउड ओके फीज आर अलाउड ऑन रिलीजियस एंडोमेंट ओके regulated expenditure okay those are not taxes. All right, now comes the article 28 freedom from attending religious instruction. So no religious instruction in institutions wholly maintained by the state funds. Okay article 28 रे तमरा चारिटा टाइप ऑफ इंस्टीट्यूशन अच्छी एटा में देखिबा exception institutions administered by state but found under endowment or trust से religious teaching allowed है पारिबो in state recognized or state aided institution where attendance in such institutions attendance and religious instruction is voluntary. Okay same जिनसो क्लीयरली ये देखिदेव चारिटा टाइप ऑफ एजुकेशन इंस्टीट्यूशन करा डिफाइन माने आर्टिकल 28 कहूँ चारिटा टाइप ऑफ एजुकेशन इंस्टीट्यूशन गोटे हूँ इंस्टीट्यूशन होली मेंटेन्ड आउट ऑफ स्टेट होली मेंटेन्ड बाय द स्टेट ओके होली मेंटेन्ड बाय द स्टेट फंड्स सेठी रिलीजियस इंस्ट्रक्शन इज प्रोहिबिटेड सेठी रिलीजियस इंस्ट्रक्शन दिया हेनी जो जो इंस्टीट्यूशन रे स्टेट एडमिनिस्टर करुच्ची बट दैट इज एस्टाब्लिश्ड बाय अंडर एन एंडाउमेंट और ए ट्रस्ट ओके तो सेठी तुम रिलीजियस इंस्ट्रक्शन इज परमिटेड ओके रिलीजियस इंस्ट्रक्शन इज परमिटेड जो स्टेट रिकॉग्नाइज्ड कि स्टेट एडेड इंस्टीट्यूशन रे तुम दैट डिपेंड्स ऑन द इंडिविजुअल चॉइस सी सेठिकार रिलीजियस इंस्ट्रक्शन हो पार बट से रिलीजियस इंस्ट्रक्शन को अटेंड करिवो कि नहीं दैट इज द इंडिविजुअल चॉइस ओके सो सेम जिनस ये लिखाई होली मेंटेन्ड बाय स्टेट से रिलीजियस इंस्ट्रक्शन इज प्रोहिबिटेड आउ जोटा कि स्टेट एडमिनिस्टर करुच्ची एडमिनिस्टर्ड बाय द स्टेट बट अंडर द नेम ऑफ एन एंडाउमेंट और ए ट्रस्ट सेठी परमिट अच्छी रिलीजियस टीचिंग इज अलाउड जोटा स्टेट रिकॉग्नाइज्ड कि स्टेट एडेड इंस्टीट्यूशन सेठी भी रिलीजियस टीचिंग इज अलाउड बट अटेंडेंस एट दैट रिलीजियस टीचिंग इज वॉलंटरी ऑन द इंडिविजुअल. सो आर्टिकल 28 अबाउट religious instruction in institutions. So चार्टा institution again 20 to 28 available to citizen plus foreigner. Okay 29 to तुम्हारा not available to foreigners. Okay article 29 protection of interest of minorities. So article 29 protection of minorities means only citizens as we have seen just now. Rights of a group, any section of citizen with a distinct language, script or culture has the right to conserve the same. Okay Supreme Court has said that it जो any section लिखा है any section includes all section any section includes both minority plus majority. Okay so Supreme Court has interpreted this like that any section means both minority and majority they have the right to preserve their own language, script and culture, and individual rights. No citizen should be denied admission into a state maintained or state aided education institution on grounds only of religion, race, caste and language. Only of. Okay now article 29 protects religious minorities plus linguistic minorities also. Supreme Court has said, as I have said, any section of citizen means includes both minority and majority. Right to conserve language also includes right to agitate for its protection and promotion. Okay, so this is Supreme Court interpretation about the minority rights. Article 30, rights of minorities to establish and administer education institution. Okay, 29 was about interest of minorities. 30 is about right of minorities to administer and establish educational institutions. So article 30 applies to all minorities. Okay, all minorities lekha hoichi, but constitution is just dita type of minority ko hoichi, religious minority and linguistic minority. Okay, e dinsata constitution re ko hoichi minority sabu lekha hoichi all minorities, but only religious and linguistic minorities are considered. Okay, article 30 deals with only minorities. Article 29 deals with all citizens. So article 30 re any minority have the right to establish and administer education institutions of their choice, and compulsory acquisition of minority institution property. This acquisition should not restrict or abrogate the right of minorities to establish and administer their own institution. Okay, suppose state रा गोटे purpose अच्छी ताको land नबार अच्छी, और that land belongs to a minority education institution, तो सी तांको adequate compensation दबो कि तांको आउ कोठी रिसेटल करेबो. जदि से तांको कंपेनसेशन न देला देन तांकर राइट टू एस्टाब्लिश एंड एडमिनिस्टर इंस्टीट्यूशन तो सेटा भायोलेट हैला, तो से जिनस स्टेट कर परिबोनी. स्टेट आइदर तांको रिलोकेट करिवो न तांको गोटे कंपेनसेशन दबो, सो दैट से माने तांकर राइट को पुणी थरे एक्सरसाइज कर परिबे. ओके, एंड स्टेट कैन नॉट डिस्क्रिमिनेट इन ग्रांटिंग एड टू माइनॉरिटी इंस्टीट्यूशन. ओके, cannot discriminate against minorities in granting aid to minority institution. So article 30 रे किछ लिमिटेशन अछि, किछ स्कोप अछि. So these protection are confined only to minorities and not all section of citizens, as I have said in article 30, not all section. Minority word is not defined in constitution. Please note this. This right includes imparting education in minorities own language also. Okay, this right is included. This right ensures equality with majority and not reverse discrimination. Okay, so this is an act of unequal should be treated unequally, or the pursuit of justice. Okay, so this is not reverse discrimination against the majority, and this right is not absolute. It does not allow maladministration. Okay, तो जोटिकर तांका एजुकेशन इंस्टीट्यूशन रे जदि तांकर क्वालिफिकेशन क्राइटेरिया कि तांकर पेमेंट टुवर्ड्स टीचर्स कि तांकर एडमिनिस्ट्रेटिव स्टाफ, तो से सबुतरे तांकर माने मिस एडमिनिस्ट्रेशन कर परिबेनी. ओके, सो दैट राइट इज नॉट एब्सोल्यूट. आ गोटे जिनस तुमर माइनॉरिटी ऊपर गोटे क्वेश्चन आसला, माइनॉरिटी कमिशन. ओके, माइनॉरिटी कमिशन. सी माइनॉरिटी कमिशन, इट इज नॉट ए कॉन्स्टिट्यूशनल बॉडी, नॉट ए constitutional body. It is not a constitutional body, but minority commission is a statutory body under National Commission on Minorities Act. Okay, National Commission on Minorities Act 1992 रे ए एक्ट रे minority commission establish करायतला. It is a statutory body. Okay, so आर्टिकल 30 रे हमें एजुकेशन इंस्टीट्यूशन ऑफ माइनॉरिटीज देखिले. एथरे तीनटा टाइप ऑफ एजुकेशन इंस्टीट्यूशन डिफाइन कराइछि. गोटे होछि education institution that receive recognition from state as well as aid from state. Okay, so these institutions are subject to state regulation. Institution that receive recognition only and no aid from state. Okay, again these institutions are subject to state regulation, and institutions that have no recognition from state and receive no aid from state, they are free to administer in their own way, but subject to general laws like contract law, labor law. Okay, ei dinsa guda tomara तथापि अप्लाई हम इन इंस्टीट्यूशन दैट डू नॉट हैव एनी एसोसिएशन विथ द स्टेट. ओके, सिमिलर टू दिस दे हैव नो राइट टू माल एडमिनिस्ट्रेशन. ओके, सो देयर राइट इज नॉट एब्सोल्यूट. स्पेशल प्रोविजन, any religious sect or community recognized as national minority can administer and establish exclusive education institutions. Okay, एटा तो जस्ट सेम कथा. derive benefits from PM 15 point program. Okay, तो देखो नेशनल माइनॉरिटी तुमर 6टा माइनॉरिटी को ही स्पेसिफाई कराई एज नेशनल माइनॉरिटीज. 6टा नोटिफाइड माइनॉरिटीज, दैट इज मुस्लिम्स, क्रिश्चियंस, सिख्स, बुद्धिस्ट, जैन्स एंड पारसीज. ओके, सो दीज आर 6 nationally notified minorities. Okay, benefit from PM 15-point program. So PM 15-point program is a program for minorities that guarantee the socio-economic development of these 6 notified minorities. Like जमती तुम एजुकेशन स्कॉलरशिप दिया कि PM आवास योजना किसी स्पेशल इनसेंटिव दिया कि नेशनल हेल्थ मिशन रे किसी स्पेशल इनसेंटिव दिया. ओके, सो 15-point program deals with minorities. Okay, so this is about 30. Tomorrow next comes the right to constitutional remedies under Article 32. So essence of 32, they are remedies for enforcement of fundamental rights of an aggrieved citizen. जदि कार fundamental right citizen रो fundamental right को fundamental right को encroach कराई, then that citizen can go to Supreme Court or High Court. It is a right to protect fundamental rights. So right to protect fundamental rights is itself a fundamental right under Article 32. Okay, so there are 4 provisions under Article 32. 32 re 32 clause 1, right to move the Supreme Court. 32 clause 2. Okay, 32 clause 2 re Supreme Court has the power to issue writs. तमरा 5टा type of writs Article 32 रे clause 2 रे कहाई. Article 32 clause 3 रे Parliament can empower other courts to issue writs, directions and orders. And 32 clause 4, right to move Supreme Court cannot be suspended except as provided by the Constitution. Okay, so ये सब गला तुमरा Article 32 रो writs ऊपर तुमरा 5टा writ अच्छी 32 रे. But please note that ये 5टा writ छड़ा 5टा रीड छड़ा जोटा कि हेबस कर्पस, मैंडामस, प्रोहिबिशन, को वारंट, सर्चुरारी, अदर रीड्स अपार्ट फ्रॉम दिस 5 रीड्स कैन ऑल्सो बी इशूड बाय द सुप्रीम कोर्ट. ओके, केवल 5 रीड्स, दीज आर नॉट द ओनली रीड्स. ओके, रीड मीन्स ए रिटन ऑर्डर. सो these are not the only writs. Apart from this, other writs can also be issued. Now Supreme Court power under Article 32. Okay, Supreme Court power to enforce the fundamental rights under Constitution is a basic feature of the Constitution. Violation of fundamental rights is the sine qua non for invoking Article 32. Okay, sine qua non means an absolute necessity. Okay, the fundamental right violate हेले ही Article 32 आसीबो. Okay, Article 32 is not there for testing constitutionality of any law or order unless they directly violate the fundamental rights. Okay, fundamental right violate हेले ही Article 32 action को आसीबो. Okay, that is the thing. Suspension during emergency under Article 359, President can suspend the right to move to court for fundamental right enforcement during a national emergency. ये दिन सोटा specify करा है that fundamental rights still exist but they cannot be enforced by Supreme Court during national emergency. So jurisdiction, Supreme Court the jurisdiction is original but it is not exclusive. It is shared with, it is concurrent with the High Court jurisdiction under Article 226. And Supreme Court, if relief is available by a High Court under Article 226, then the party should first move to High Court, then the Supreme Court. Okay, Ambedkar has said on Article 32, it is an article without which the Constitution would be a nullity. Okay, so this article बिना Constitution का किसी फायदा ही नहीं. He called this Article 32 as the very soul and heart of Constitution. Okay, so please note this point. एटा तमरा mains रे भी answer लिख पारिबो. Okay, now the types of writs. Writs, as I have said, writ is a written order. These are borrowed from English prerogative writs. Fountain of justice. Okay, fountain of justice means these are prerogative writs. Prerogative writs means reserved for someone. Okay, माने exclusively reserved for someone. Okay, English रे prerogative writs were, these writs were reserved for the king, and king was considered as the fountain of justice. Okay, so सेही जिनस इंग्लिश लॉ रू ही आमर रिट्स गुड़ा रिट्र कॉन्सेप्ट वी हैव डिराइव्ड दैट. सो authority of the writs, Supreme Court under Article 32, High Court under Article 226, Parliament can empower other courts also to issue writs. Okay, now types of writs पांचटा अच्छी तमर habeas corpus to have the body of to release a person who is unlawfully detained or imprisoned. Okay, that is the mandamus to produce someone who has been unlawfully detained or imprisoned in the court of law. So court orders the detaining authority to produce the person to check the legality of the detention. It cannot be issued when the detention is lawful. In case of contempt of court or contempt of legislature, detention ordered by a competent court or person detained outside the jurisdiction of a court. Okay, এই case रे habeas corpus तमरो invoke करी हबनी. Okay, habeas corpus serves as the bulwark. Okay, bulwark means supporting structure of individual liberty. Bulwark of individual liberty against arbitrary detention by state as well as private person. Okay, so it gala tamar habeas corpus. Now mandamus is means we command. Okay, mandamus re state jo judiciary says to do. Okay, ita karo, we command. It directs the public authority to perform their statutory or public duty. So again, it can also be invoked against a public body, corporation, or an inferior court or a tribunal also. Okay, judicial body manakar pi upare mandamus pi use karibo against an inferior court or a tribunal. So but cannot be issued against private individual, non-statutory departmental instruction. Okay, because departmental instruction जो statutory status नहीं तो सेटा को बाध्य करी होबो डिपार्टमेंट ऊपर. डिस्क्रिशनरी ड्यूटी जदि गोटे ऑफिशियल डिस्क्रिशन अच्छी सेटा काम करिवो कि नहीं, देन सुप्रीम कोर्ट कैनॉट फोर्स दैट ऑफिशियल टू डू समथिंग. ओके, कॉन्ट्रैक्चुअल ऑब्लिगेशन ए कॉन्ट्रैक्ट रे ही तमर ऑब्लिगेशन गुडा को डिफाइन कराई थाए तो ता बाहर को जाई कि सुप्रीम कोर्ट मैंडेटस दबोनी. एंड अगेंस्ट प्रेसिडेंट, गवर्नर्स और चीफ जस्टिस एक्टिंग इन जुडिशियल कैपेसिटी. ओके, this is mandamus. Prohibition is to forbid, not to do. Okay, mandamus is to do, provision is not to do. Not to do. So it is used when a higher court prevents a lower court or tribunal from exceeding or usurping jurisdiction. Okay, so this applies to only to judicial and quasi judicial bodies before the final order is passed. Before final order is passed, Supreme Court can issue prohibition. Okay, final order passing purvuru. It is not available against administrative authorities, legislative bodies, and private individuals and private bodies. Okay, this is prohibition. Certiorari to be certified or to be informed. Okay, certiorari देखो ये prohibition जेमती before final order is passed, certiorari is issued after the final order is passed. All right, after the final order is passed. Okay, to quash the decision of a lower court. Okay, so certiorari, higher court reviews the decision of a lower court, and the higher court can quash the decision if it is made without jurisdiction in violation of principles of natural justice. Okay, so certiorari applicable to judicial bodies. Okay, but in 1991 certiorari was extended to administrative authorities also, but it is not available against the private individuals, the legislative bodies and other bodies. Okay, so this is all about certiorari. Quo warranto means by what authority, by what warrant. Okay, means it challenges the legality of a claim to public office. It restrains a person from acting without authority, asking the person to prove legitimacy of acquiring that authority. So it is applicable to substantive public office of permanent character created by statute or created by constitution. It can be filed by any interested person, not just the aggrieved party. Okay, quo warranto means by what authority, by what warrant. Okay, now comparison of jurisdiction. Supreme Court under Article 32, High Court under Article 226, Supreme Court narrow jurisdiction only restricted to fundamental rights, but High Court wide jurisdiction fundamental rights भी violation रे कि any other purpose यदि violation हला तो High Court has wide jurisdiction to issue writs on any number of other legal rights also, not just fundamental rights. Territorial reach, Supreme Court can issue writs throughout India. High Court can issue within its jurisdiction or in outside jurisdiction if the cause of action arises within the jurisdiction. Okay, जदि बाहर कोटी हेची आउ तारा इफेक्ट पड़ुची हाई कोर्ट जुरिस्डिक्शन अंडर भितर तो सेई केस रे हाई कोर्ट कैन साइकोर कैन इश्यू रिट्स बियॉन्ड इट्स जुरिस्डिक्शन. nature of remedy, it is mandatory. Remedy under Article 32, okay, 32 in fundamental rights, Supreme Court cannot refuse remedy, but High Court may refuse the jurisdiction. It is the discretion of High Court. Okay, now comes the Article 33 to 35, Armed Forces and Fundamental Rights. Article 33 restricts the fundamental rights for armed forces and others. Okay, now Parliament can restrict or abrogate fundamental right for member of armed forces, paramilitary, police, intelligence agencies and other forces. These the purpose is to maintain public order and discipline among the forces. Okay, so parliamentary law under Article 33, it can also exclude court martials from High Court and Supreme Court writ jurisdiction. Okay, but please note, Parliament can exclude court martial are tribunal. These are court martials are tribunals that are established under military law. Okay, Parliament can exclude court martial from High Court and Supreme Court writs, but only as far as the enforcement of fundamental rights are concerned. Okay, if the court martial can be challenged by High Court or Supreme Court for violating laws other than fundamental rights. Okay, other than fundamental rights, then that can be challenged. Okay, so this is the thing, that only Parliament can issue these laws, restriction for fundamental rights, and not the state legislature. Only Parliament has the exclusive power. So according to this power, Parliament has enacted the Army Act, Navy Act, Air Force Act 1950. Okay, so 1950 रे तमरा Army Act, Navy Act, Air Force Act एटा सब Parliament issue करछि. Okay, to maintain discipline, these laws cannot be challenged in a court on ground of contravention of fundamental rights of the armed forces, and it applies to all members of armed forces. Okay, including combatant and non-combatants. Okay, तो barber, carpenter, अलगा जो माने सब staff अछंती, जो माने non-combatant staff, तांको ऊपर भी ये law applicable हबो. Okay, now Article 34, martial law and fundamental rights. So this martial law is borrowed from English law. So martial law means military rule, civilian administration run by military authorities under their own rules and not ordinary rules. Okay, ordinary law को हटाई दिया जीवो, military rule will be used to administer civilians. Okay, it implies suspension of ordinary law and governance by military tribunals. It is different from military law. Okay, military law applies only to armed forces. Okay, military law applies only to armed forces and is not equal to the martial law. Martial law is applied to civilians. Okay, civilians who are for the time being ruled under military rule. Okay, so Supreme Court has declared that declaration of martial law is not automatic suspension of habeas corpus. So this was declared in the ADM Jabalpur versus Sipkan Shukla case. Declaration of martial law does not lead to automatic suspension of habeas corpus. Okay, Parliament can indemnify government servant and others for act done under martial law. Indemnify meaning is to justify the action of. Parliament can make laws to justify action of government servant and others for acts done under martial law. Indemnity Act of Parliament, okay, this cannot be challenged for violation of fundamental rights. Martial law constitution define करा जाएनी. There is no explicit provision for declaration of martial law. It is implied in Article 34. Okay, Article 34 martial law mention करा आइची, but सेटा कोडी पल्से define करा जाएनी. Okay, martial law national emergency भितर एटा तम लक्ष्मीकांत रो टेबल थिला. Okay, martial law affects only the fundamental rights. National emergency affects fundamental rights, center-state relation, revenue distribution, legislative powers, tenures of parliament, everything. Okay, national emergency रो wide area affect हुए इधर खाली only fundamental rights. Okay, but only fundamental rights, but habeas corpus is maintained. Okay, please note, government suspends the government and ordinary courts, but here national emergency government and ordinary courts they continue to function. Reason, breakdown of law and order by any reason. National emergency only on the ground of war and external aggression or armed rebellion. Extent, it can be imposed in specific areas. Okay, it can also be imposed in specific areas or the whole of country. Martial law kichi implicit under Article 34. There is no specific article. National emergency explicitly detailed constitution under Article 352. Okay. Now Article 35, power to make laws. Okay, Parliament alone can make laws to give effect to certain fundamental rights. It ensures the uniformity of those laws across India. State legislature have no power in these matters. Okay, को जगह मेंशन कराई आर्टिकल 35 रे, आर्टिकल 16 रे तमरा Parliament can prescribe residence as a condition for certain jobs. Article 32 रे Parliament can empower other courts besides Supreme Court and High Court to issue writs. Article 33 रे Parliament can restrict fundamental right of armed forces, police, paramilitary forces, etc. Article 34 रे Parliament can provide for indemnity of a government servant or others for acts done under martial law that cannot be challenged under fundamental rights. Okay, Parliament also has the power to prescribe punishments under Article 17, abolition of untouchability, under Article 23, prohibition of human trafficking and forced labor. Okay, so please note that Article 35 extends Parliament's competence even on matters in the state list. Okay, so if while enacting laws to implement these provisions, the Parliament has to encroach on the power of states, okay, even that is also allowed. Okay, Article 35 extends the Parliament's competence to encroach on matters even in the state list. So note this thing. Exception to fundamental rights, what was Article 31A. Okay, Article 31 has been repealed. The property rights 31A achi, protection of certain laws. What are the laws? Panchata category of law achi that are protected from challenge under Article 14 and Article 19, that is acquisition of estates and related rights by the state, taking over management of properties by the state, amalgamation of corporations, extinguishment or modification of rights of directors and shareholders of a company, extinguishment or modification of mining leases. Okay, so this panchata law Article 31A रे protected अछि. Okay, panchata category of law 31A रे protect करा है तो याको implement करिया गो हले Article 14 और 19 को violate करिया गो हले that cannot be challenged in the court. Article 31B 9 schedule article. Okay, फर्स्ट आमेंडमेंट 1951 रे 9 शेड्यूल आड करा हितला. ओके, इनिशियल कॉन्स्टिट्यूशन रे 8टा शेड्यूल थला, 1951 फर्स्ट शेड्यूल रे 9 शेड्यूल आड करा हला. लॉस प्रिविलेज्ड हियर आर इम्यून फ्रॉम चैलेंज फॉर वायोलेटिंग फंडामेंटल राइट्स इन द बट इन द आईआर कोहेलो केस देयर इज नो ब्लैंकेट इम्यूनिटी फॉर if the law is placed in the 9th schedule also, then also judiciary can review that law. Okay, because judicial review is a basic feature of the constitution. Laws placed in the 9th schedule after 24th April 1973, the Kesavananda Bharati case, are open to challenge if they violate fundamental rights. Article 31C, DPSPs, any law implementing DPSP in Article 39B. 39B is the ownership and control of material resources of community should be so distributed to best serve the common good, and Article 31C, operation of economic system should not result in concentration of wealth and means of production to the common detriment. Okay, so any law implementing DPSPs cannot be said to be void for violating Article 14 and 19. बाकी रहा राइट्स आउटसाइड पार्ट 3, these are not fundamental rights, they are legal rights or constitutional rights but not fundamental rights. जमती पार्ट 12 रे आर्टिकल 265, सेम पार्ट 12 रे आर्टिकल 300. ये जिनसा मन रख, पार्ट 12 रे आर्टिकल 300 ये अच्छी. Article 265, no tax shall be levied or collected except by authority of law. This is important. Article 265. Article 300A, no person shall be deprived of property except by authority of law. Okay, so these are constitutional rights. Article 301, freedom of trade, commerce and intercourse throughout India shall be free. Article part 13. Okay, 8 जिनसा मन रखा, part 13. And part 15 तमरा Article 326 deals with elections. Part 15, right to vote, universal adult suffrage is a constitutional right. Okay, तमरा 61st constitution amendment act तमरा it lowered the voting age from 21 to 18 to the Lok Sabha and state assemblies. UDHR रो किसी concept अच्छी तमरा fundamental rights संगे universal declaration of human rights 1948 रे act करा हितला, adopted by UN General Assembly on 10th December 1948. Please remember this date. This is the International Human Rights Day, 10th December. Okay, so UDHR declared 30 rights and freedoms that belong to everyone. Key provision, Article 26 of UDHR, right to free and elementary education. Okay, एटा तमर आर्टिकल 21A रे अछि. Article 27 सेमती right to cultural participation and protection of intellectual work, that is also in fundamental rights. UDHR promise economic, social, political, cultural and civic rights. Okay, तो UDHR जो सब राइट गुड़ा अच्छी तांकर कैटेगोराइजेशन करा ही पारिबो, लाइक सिविल राइट्स, पॉलिटिकल राइट्स, इकोनॉमिक, कल्चरल राइट्स, पॉलिटिकल राइट्स. ओके, सोशल राइट्स तो सेमती आमर फंडामेंटल राइट्स को कैटेगराइज करा जाई परिबो अंडर सिविल एंड पॉलिटिकल राइट्स डीपीएसपी को कैटेगराइज करा जाई परिबो अंडर सोशल एंड इकोनॉमिक राइट्स ओके सो यूडीएचआर भी सेमती कैटेगराइजेशन करी हबो इंडियन रिफ्लेक्शन ऑफ यूडीएचआर प्रिएम्बल रे यूडीएचआर किछि वैल्यू अछि जैक जस्टिस इक्वालिटी एंड लिबर्टी तमर आर्टिकल 3 ऑफ यूडीएचआर रे राइट टू लाइफ लिबर्टी एंड सिक्योरिटी को हाइछि डीपीएसपी आर्टिकल 22 ओके डीपीएसपी आमर जमती अछि सोशल एंड इकोनॉमिक राइट्स आर्टिकल 22 ऑफ यूडीएचआर दे गारंटी सोशल सिक्योरिटी एंड जस्टिस और फंडामेंटल ड्यूटीज आर्टिकल 51A okay civic obligation duty to provide education for every child 6 to 14 years of age so it is a fundamental right that is in alignment with the right to human dignity because education no hale tamara human dignity maintain kari hobani okay that is also a mandate of UDHR okay so with this we complete the fundamental rights chapter.